Distinguished arbitrators, good afternoon. My name is Liu Juan from International Dispute Resolution Center of HIAC. On behalf of HIAC, I would like to extend a warm welcome to all of the arbitrators attending this training session online and offline. And thank you for attending this training session. To ensure the quality of the training session, we would like to kindly remind you that attending online, please mute your microphone and turn on your camera. Thank you for your cooperation. As you may know, the credibility of arbitration is the cornerstone of arbitration system to improve the quality of arbitral awards and to standardize the handling rules of the conflicts of interest of arbitrators to provide more professional and higher quality arbitration service to the parties is the guarantee of the credibility of arbitration. To improve the ability of arbitrators to write arbitral awards and to standardize the handling rules of conflicts of interest to improve the quality of arbitration, we organized this training session. First of all, let's welcome Mr. Wang Xuelin, Chairman of HIAC, to deliver an opening remarks. Now let's welcome. Dear experts, dear fellow arbitrators, friends, good afternoon. We are entering into a winter season and we are approaching the end of this year. It is a great pleasure to meet you on the cloud, to meet all of the arbitrators. Today, we organize these training sessions focusing on two themes. One is how to draft the arbitral awards instruments, and the second issue is how to handle the conflicts of interest involving the arbitrators and the parties. These two issues are of great importance to our arbitration work. And these two issues we also attach great importance to when we are conducting arbitration procedures. We are very honored to have invited two experts who have done in-depth research on these two issues. On how to write or draft arbitral award, you may know the importance of arbitral award. First, for the tribunal, the award reflects the level and professionalism and attitude of the arbitral tribunal. It is also the cornerstone of the efficiency, high quality of the arbitration procedure. For the parties, the arbitral award is the determinant factor determining whether the parties will accept the arbitration outcome. The quality of the arbitral award reflects the parties' acceptance and recognition of the arbitral tribunal arbitral system. The quality of the award is also reflecting the functioning of the arbitration institution through working closely with the arbitral tribunal. We work hard to improve the credibility of the arbitration. How to give full play to the advantages of the arbitration system? This is reflected in the arbitral award. Compared with litigation and mediation, arbitration has the advantage of being final and binding. But can we give full play to this advantage? The importance lies in arbitral award and whether our arbitration outcome can pass the review of the People's Court, or can it be enforced and recognized by the People's Court? The quality of arbitral award is of great importance. Whether it balances the interests of the parties, whether it is written of high quality, this determines whether the People's Court recognize and enforce the award. And it is also indicated on how the public measure the level of arbitration and arbitrators. It is a great tool for us to promote the awareness of arbitration. So arbitral award is of great importance to all of us involved in this arbitration system. We are honored to have invited two experts. First, we have Ding Jianyong. He is Deputy Secretary General of the Beijing Arbitration Commission. He has done in-depth and comprehensive research in this regard. Another keynote speech addresses arbitrators' conflicts of interest and handling rules. We have invited Zheng An Zhang, Tony Zhang to address you on this issue. He has been involved in several sessions on this theme today. He will share with us his experience and research outcomes during the past few years. And he has also summarized other practitioners' experience in the past few years. We know that the arbitration system is very strict. For the parties, arbitral tribunal and the arbitrators and the parties, the conflicts of interest involving these all three parties are of great importance. Whether there is potential conflicts of interest is a sensitive issue to the parties. We all attach great importance to conflicts of interest. In particular, the potential conflicts of interest between arbitrators and other parties involved. Its complicatedness has beyond our expectation. We must have a correct mastery of this issue to fully guarantee the legitimate interest of all the parties, but at the same time support the work of the arbitral tribunal and to lend the best support and protection to the arbitrators and the tribunal. So we believe that this theme, we should hold a session to discuss this theme and issue. How we handle conflicts of interest, it is also an indicator to measure the work of the arbitration institution. As you may know, that HIAC has established a three-pillar management mechanism. So we want to make efforts to improve the work of all these three parties involved in this system. We hope that through these training sessions, you will have a better understanding of HIAC and the management rules and handling rules of HIAC, and better understand each other. With the great support of the experts and arbitrators, HIAC have achieved a lot in terms of reform and management improvements. In particular, in 2022, were included in the one-stop international commercial disputes resolution mechanism as listed by SPC. In particular, now Central Committee has expressly laid down requirements on the free trade ports of Hainan province and to build HIAC as a legal window and dispute resolution window with influence around the whole country and around the whole Eastern Asia. So the quality of arbitration, the quality of arbitral award is of great importance. We believe that through our concerted efforts, we will yield more impressive results in this regard. our former president Jiang Zemin, in his visit to Hainan in 1993, he also once put forward his expectation to Hainan province. Though most of the country is in cold winter, but Hainan province is still in a spring climate. So we welcome all you to visit Hainan province to take a visit around Hainan to see the results of our development of free trade ports in Hainan. We believe that with our concerted efforts, we will give full play to the advantages of Hainan province, Hainan's free trade ports, and HIAC, so that we will further opening up our markets and to fully practice President Xi Jinping's thoughts on rule of law and his thoughts and requirements on putting ADR in the first place. So much for my opening remarks. Lastly, I would like to everything goes well with you and wish this event a great success. Thank you. Thanks to Mr. Wang for your opening remarks. Next, we will give straight to the main theme. The first keynote speech will be delivered by Ding Jianyou. He is from 2005. He began his work in in Beijing Arbitration Commission. He is now the Deputy Secretary General of Beijing Arbitration Commission. He is in charge of the handling of arbitrators and domestic cases. He has been in charge of over 5,000 cases. He is familiar with the arbitral award document writing, and he has won the award of model arbitrators issued by the Department of Justice. His research theme is how to involve the commercial dispute resolution in evolving markets and legal environments. And he is also an author of several books. Next, let's welcome Mr. Ding. His theme is practice of writing high-quality arbitration award documents. Mr. Ding, good afternoon. Thank you. I will share my screen first. Can you see my screen? Yes. I will begin my keynote speech now. Distinguished Mr. Wang, distinguished fellow arbitrators, good afternoon. It is a great pleasure to have this opportunity to deliver this keynote speech on the high-quality writing of arbitral award to you. Some of you are my colleagues in Beijing Arbitration Commission, some of my teachers. In terms of how to write the arbitral award, actually there is no one solution for all. I would like to share with you my experience when I handle the cases and when I deal with the arbitrators and the parties to the arbitration. And please raise your opinions and comments at any time. I will deliver my speech from four perspectives. First, attitude and preparation. Second, standards and logics. Third, features and language. And the last, efficacy and skills. You may have a basic understanding that what type of content or what type of instruments is considered as a good arbitral award. I have made a quote from this is a quote from the International Arbitration Practice Guidelines issued by CAARB. So first, we must bear in mind that the arbitral award is written for the parties. So the more likely it is accepted by the parties, the less likely it is challenged. And second, we need to consider the wider audience, also other stakeholders, for example, the judges. That is to say, they do not need to deep into the arbitration procedure, but with the arbitral award, they can see the level of the arbitration.
那么我们简单概括一下呢，高质量的裁决一般呢可能有3个部分。第一呢，
So there are 3 parts for a high-quality arbitral award. The first one is formality, and the second one is substantial content. And it is a dispute resolution institute mechanism so that to end the dispute, so that we should have evidence and also the reference to the law, and also in words, so the language should be simple and also stick to the principle of neutrality. So I'd like to share some of my thoughts and experience for you. So for I myself, I'm always doing the verification and the proofreadings from the perspective of the institute, and also editing of the arbitral award. So I'd like to share some of my experience from my perspective. So the first one is pay attention to that, and also preparations. Our Director 1 has said that's the importance of the arbitral award. So, and I'd like to introduce to you the arbitral award, not only for the applicants, but also for the other parties. So for the parties, the results is the most important one because it's a final and binding one. And also for the application of law, if there's any faults, flaws, then remedies will be sorted. When I meet with lawyers, law firms, they pay special attention to the, for example, large amount of disputes. They don't want to choose to arbitrate because the reason is that simple facts to choose arbitration, high efficiency. However, the large amount of disputes, there's no remedies. In courts, they have a second trial or appeal, but however, for arbitrations, it's final and binding. So for the arbitration, this is the final judgment. So whether it's fair, where it can be enforced or can have proper remedies. For arbitration institute, the credibility will be reflected by the high quality arbitral award. So the procedures and the other things will lead to the arbitral award. And it will also determine your position in the arbitral award market. They will not choose you, and then your positions in the market will decrease. And also for arbitrators, it is a demonstration of your professionalism, no matter it is the arbitrators, they have very good feelings and they are confident on themselves. We will not doubt on that. However, but the arbitral award, it will not meet the basic requirements, so that it is not competent for arbitration. However, they want to have some appointment in the arbitration centers. So we will look at the selection of arbitrator, especially for the large amount of complex cases. You're going to see the professionalism of arbitrator. And the key factor is the quality of arbitral award. Many of the domestic cases, selection of arbitrator, and the arbitrator, they ask me, what is the criteria for recommendation of arbitrator and what contributions or have good relation with arbitration institute. It is not. You make good quality and you make high quality arbitrary award. We will not look at you at other criteria. You will reflect on yourself whether you have done good quality arbitration, good quality arbitral award. And for the judges, they have judicial reviews for the arbitral award. The procedure, is it a standard? And is it comprehensive? And also the evidence side and also the public interest. And for the third parties, outsiders, whether this arbitration is fraudulent, whether it will harm the third party's legal rights. And the second part is to do good preparation work. The first one is to look at the procedures. And today I'm saying the drafting of the arbitral award. The first one is to have a procedural list, whether any missing point, or for example, cross-examination, and also whether we should have outside investigations. And the second one, whether all the materials of the case are fully listed, are fully included. And the third one is whether there's a primary comment for the arbitral panel, arbitral court. It is, I suggest that for the panel, they have a meeting, they have a primary meeting, so that they make they reach a basic consensus or express their opinions. And also there are any special cases that need communication beforehand. For some cases, for example, social stability, the Secretariat has reflected some cases that it need to consider social stability situations, or it is related cases, and or can the institute provide the relevant cases. And the fifth one is definite arbitral award results and also the rationales. The sixth one is relevant cases, laws, articles, legal research, so that, for example, similar cases in the court. And the next point is that to have enough time and reviewing time for the time limit for submitting draft. Because, for example, Beijing Arbitral Court, 40 days before the deadline, and also the standard to submit the draft. I like to say that in practice, arbitrators submit draft, and the draft, the standard is that it is ready to send to the both parties of the arbitration. It's not the so-called draft. It is in fact that is ready to be seen by both parties. For example, evidence, application of law, results. Still, some blank or improvements need to be made. So the institute need a lot of energy and time efforts to improve this draft. If we say that this is a final opinion of the arbitrator, however, the standard is not meet our criteria, this is the criteria or standard that you just give me the opinion, the draft. However, if it's for final review, then I'm using the standard for final review to proofreading your draft. This is also the impression the arbitrator will give for the institute. And the second is the standards and the logic. So HIAC International Arbitration Court, it has a stipulation on the arbitral award draft regulations. So if we stick to that strictly, most of 90% are high quality final awards, arbitral awards. So let's look at our stipulation, the preambles, facts, and the opinions of the arbitral court, and also the full article of the arbitral award. The preambles, the basic information, rules for receiving the case, application of rules, and the composition of arbitration court, and the procedure progression, and the demonstration of the due process, etc. So, for example, the composition of arbitration court. This is because for the judicial review of the arbitrations, it is mostly procedures. So we should say that we have the rights, authorities to look at this case. And it is comply with the principle of due process and also natural justice. And this, for example, the jurisdiction disputes, jurisdiction complaints, then we will see all the application of the relevant rules and to elaborate so that if in the future there's a judicial review, the judge look at it, then it will justify the due procedural process. For the court will not revoke the arbitral award if there's no solid foundation. And then the facts, we know that the premises of writing an arbitral award, that is, first we will introduce the claims from both sides. It will reflect the facts and also the rules of law and also the disputes that we will summarize the legal claims and will not copy the claimants from both sides. And it will reflect claims and the rules and the evidence from both sides. Many of the opinions and our opinions from the arbitrators will reflect these disputes, these claims, and some key points that for the main points, opinions, there should be an introduction, no missing and not copying. It's good summary, and also it should go through the cross-examination, and also the main facts should have relevant evidence to support. For example, construction dispute for the amount of the settlement, you can use annotated ways to express, to elaborate with proper reference who said that, so that we can use annotated ways to reference. Many of our arbitrators has this kind of habit. And some of the main problems or frequently seen problems, let's look at that. That is reference of law, reference of article. Some of the draft is quotation of the previous contract, and they quote the whole contract. So in Beijing Arbitration Court, yes, we have these frequently met questions.
This is maybe a dispute surrounding the liquidated damages. So you just need to write down the article surrounding the liquidated damages. You do not need to write down the other articles irrelevant with the provision of liquidated damages. That will make your documents not well targeted against the facts. And after reading your documents, we will not know the points at issue in this case. So we do not recommend that arbitrators to invoke all of the contractual provisions in their documents. And I would like to remind you that how the secretary should judge whether the award is written by arbitrators themselves or written by the secretaries or students entrusted by the arbitrators. So this is one of the major measures for us to judge whether the arbitral award is written by the arbitrator he or herself. For some arbitrators, if he or she is very busy with many cases, so he or she will not have time to write down all of the contractual provisions. So in some cases, the arbitrators will entrust his or her secretary or students to write down all of the contractual provisions. But the secretary or the students does not know the major issues at points in this case, so write down all of the contractual provisions. This is not good for us. The other frequent problem is the copy and paste. It is actually of debates and controversy. Some arbitrators tell me that when you are given training session, you say that we must respect the opinions of the party. So I copy and paste all of the opinions of the parties. But the parties will not have opinions and objections to this method. In some cases, I see that the arbitrators copy and paste all of these, for example, 1 to 5 claims and opinions in the arbitral award, but some are overlapping and repeated. So this will impact the quality of the arbitral tribunal. And sometimes in expressing his or her opinion, the parties might criticize the arbitrators or use other indecent language. So if you copy and paste all of the opinions expressed by the parties, that you may have written down some indecent language. So you do not need to copy and paste without any omission of the opinions of the parties. The third part is the opinions of the tribunal. This part deliberates upon the logic, reasoning, and judgment based on facts and legal grounds, determines the legal responsibilities of the parts. This part is the foremost part of the arbitral award and the best to reflect the legal accomplishments and professionalism. And some textbooks on how to write arbitral award will dwell much upon this part. In my view, we need to master 3 requirements and 3 approaches. We'll list these 3 requirements and 3 approaches for your reference. 3 requirements. First, you need to have a legal ground. Second, you need to answer the questions. Third, you need to respond to the needs of the parties. In Beijing Arbitration Commission, we held an internal session and we laid down these 3 basic requirements to screen the arbitral award. Legal grounds, which means that the reasoning shall be grounded on legal provisions, facts, and contractual provisions. I will give you an example. The respondent fails to deliver goods within the specified time period in breach of the Article 7 of the contract. In accordance with Article 8 of the contract and Article 114 of contractual law, the respondent shall pay 500,000 yuan in liquidated damages to the respondents. So there is contractual provisions, legal grounds, and facts in this wording. When the case is complicated, if there are many evidences to be affirmed, if you do not have 100% of mastery of the case, then you can add that based on the existing evidence, we cannot affirm the facts you put forward, or based on existing evidence, we can affirm the facts. So add the premises that based on the existing evidence that will leave room for you to argue in the future, because now with more and more cases, with the cases becoming more and more complicated, there will be many disputes surrounding the arbitration proceedings. Sometimes we will accept the officials from the public security organs to do investigation into the arbitration proceedings. On the doubt that there may be falsified evidence. So when we are writing the arbitral award, we must add the premise based on the existing evidence to avoid any challenge or objection in the future. The second requirement is to answer the question of the parties. For the respondents, he will defend and make pleas to every claim of the claimant. You may not need to detailedly dwell upon the claimants, but put forward the major pleading opinions of the respondents. For those unnecessary, supplementary, you can't make replies, but you do not need to give details. For example, and you can give the reason. For example, this is irrelevant with the case. You just need to make the parties understand that your pleadings or your defense have been received by us, but we think that this is irrelevant with the case. Sometimes if you overlook these opinions in the arbitral award, the parties may think that you omit their opinions. So you can just touch upon the unimportant opinions of the pleadings. For example, the respondents may have put forward 6 to 7 pleadings to the claims of the claimants. After the arbitration, the tribunal believed that among the 7 claims, there is one major claim to be supported and affirmed. So we can give full details of explaining the opinions of the pleadings and claims. For the other 6 pleadings and claims, they are not important issues at points. Whether they can be supported and affirmed, they will not impact the outcome. So we can just touch upon the opinions. For example, you can write down that for the other 6 pleadings and claimants, the tribunal believes that we can decide on the case based on the first opinions. The third requirement is to respond to the claims and counterclaims. Whether they are wrong or correct, you must give your opinion as to support or refuse the claims and counterclaims and give clear explanations. You need to respond to the claims and counterclaims. You may not be able to support each claims or counterclaim, but you need to make replies, make response to the claims, which include procedure claims and counterclaims. When we're reviewing the arbitral award, we find that some of the claims regarding the procedure of the arbitration, the tribunal may just make oral response, but do not put down the claims on the arbitral award. We believe that you still need to write down all of these claims and counterclaims regarding the procedures. There will be issues of excess arbitration or insufficient arbitration, which will give grounds for refusal of enforcement and recognition. Next, I will talk about the basic formality. I have read the rules of HIAC. We have the same basic requirements. First, the validity of the contracts. Next, the reasoning of the arbitration. The reasoning shall be logic-based, well-targeted, grounded on law and comprehensive. Some experts mention also that facts, legal grounds, and reasons shall all be explained clearly in the arbitral award. How to do it? In my today's course, I will put emphasis on practice rather than theory. First, we must be clear of the logic pattern of syllogism. For the case, what are the facts to be affirmed and what is the decision made by the arbitral tribunal? Next, the reasoning shall be folded logically or in the sequence of complaints, item by item. There are three approaches. First, claims-oriented. Second, pleading-oriented. Third, deliberate on the points and issues. In HIAC, the focus is the third one, deliberate on the points and issue. First, claims-oriented. It applies to arbitration with the absence of the claimants and because the claimants have put forward sufficient evidence and which are not refused by the respondents. So in this situation, you can apply the claims-oriented approach. You write down the claims of the claimants item by item and list the evidence supporting each claim, and then clearly explain the opinions of the arbitral tribunal. The first part, the validity of the contract, and next, you'd write down the claims of the claimants item by item, and then third, write down the fees of arbitration. This is a simple approach. Though it is simple, you may think that this approach cannot reflect your professional level, but actually it is not easy to write down a good claims-oriented approach. In BIAC, 80% of our cases, most of the cases are ordinary cases, regular cases, and simple cases. You can produce a good arbitral award following this claim-oriented approach. With this approach, you will not overlook or omit the claims of the claimants because you need to write down the claims one by one. Claims 1, claims 2, claims 3, very simple formats. Most of the cases can adopt this type. The next approach, pleading-oriented, it is exceptional. Most of the cases are not ideal for this approach, but for some exceptional cases, we can use pleading-oriented approach. This approach starts on whether the pleading of the respondent established. Sometimes the evidence of the claimants are not sufficient. And we also find that the pleadings of the respondents are weak, or there is logic problems of the pleadings. But the problem is that the evidence of the claimants are not sufficient. For example, there is no key evidence supporting the claims, or there is deficiency with the direct evidence. For example, there is no original copy. There are just witness opinions. And for example, the documents there is no original copy, or the documents are ambiguous. But there are many inconsistencies, contradictions with the pleadings of the respondents. And the respondents' pleadings are very weak, avoiding key issues. Or maybe the respondents are intentionally shifting away the attention of the arbitral tribunal. So in this situation, you can adopt pleading-oriented approach. You can write down each pleading opinions of the respondents one by one, and then you need to refuse each pleadings one by one. And then give your opinions as to the support of the claims of the claimants. So you are saying that because the pleadings are weak, so you support the claims of the claimants. This is the second approach. The third approach is to deliberate on the points at issue. The arbitrators may induce the points at issue in the dispute one by one and explain each item by item, and then go back to the claims of the claimant and to give your opinions as to whether to support the claims. The fees and the claims are the common parts of these three approaches, but the first part will differ among these three approaches. You may give the claims, you may write down the contractual validity first, or write down the pleadings first, or write down the points at issue first. These are the difference of these three approaches.
And for the opinions, so from the following aspects, the first one is elaboration and application of law, and also request. So I'd like to introduce to you one to one. The first problem, that is a lot of redundancies of explanation, rationale. You may know that the logic that we like to use elaboration, that is to supplement the draft, the award. However, you should make notice that the conclusion, the process that need to be verified, justified, or do not left any flaws or any mistakes. That, for example, for the construction dispute, that to claim for the money for the construction fees, that is, the construction project has been demolished. There's no evidence that the the construction work has been done. No signing, no practice, put into use. And the rationale is that there's no evidence that to justify the completion of the construction work. However, it has already 7 years. So the arbitrator add one sentence that even if the construction work has completed, however, it has overseen the time period of litigation. So this is the flaw. This is not the content that the arbitral panel, arbitral court should look at. And that is, the application haven't applied, submitted for the claim for the limit of time limit. However, then we got complaint that the focus is not whether it has evidence on the completion of the construction work. And the complaining is that why the arbitrator thought that it has surpassed the time limit, so that this is the flaw. And also, we didn't, the other side didn't defend on the time limit. However, you have made a conclusion that this has already passed the time limit. So this is one example that this kind of draft writing, it has flaws. And the second one is outside the expectation. That is, it's a hidden problem. Let's give you an example. For light purchase dispute, the applicant supply goods light to the defendant. That if, and in this case, if there's quality issues, problems, then all the monies, all the purchasing monies will be returned to. So what is the meaning? That any quality product will lead to all return of the money. So they have different interpretations. So in the hearings, in the trials, the claimant claims that there's quality problem and also give a quality inspection report that 1/3 of the goods has a problem. The first is that the defendant do not recognize the credibility of the quality investigation report, and also the goods are not provided by the defendant. So there's no quality problem. However, the defendant says that any problems will lead to all return of the money. So it's 7 million. 2 million has been paid. 5 million need to be paid. So they claim that the 5 million will be returned. That, but the other party said 2 million has 2 million goods has quality problems. So the arbitrators thought that will return those amount of money matching with those goods which has quality problems, not all the goods amount. So they sustained that 3 million will be returned to the seller, to the buyer. So this article, the all return all money. So which does it refers to? So it refers to the whole amount of goods or only those who has quality problems. So the arbitration court didn't ask, and also the interpretation problems. That is the 7 million. If it's 7 million, then it's punitive damage, punitive attributions. However, the arbitrator didn't ask, and the arbitrator didn't ask, solicit opinions from both sides, but has made his own conclusions. This is a risky behavior. That is no solicitation of opinion from both sides, so that we have another hearings for the interpretation, understanding of this article. This is our remedies from the perspective of Arbitration Institute. Problem is the avoidance of the claims that software purchase contract disputes. The defendant is a seller and applicant buyer. That during the use of the software, many problems. and the applicant telephoned noticed the seller, please come and service on site. That the after-sale service. So the continuation of the performance of the contract. That the service at site is not come in person, but can be conducted, serviced remotely, for example, by internet. So that if you open a portal of the internet, then I can log into it. And you didn't log into the remote service because of the COVID-19 reasons. Because the user, it has some confidentiality requirements. So it didn't open the internet portal to the seller. So the arbitral award right that it has an obligation to service on site. So the continuation of the performance of the contract is sustained. The continuation of the performance of the contract, it writes. So it's a risky one if the continuation of the performance, it didn't solve the disputing point. So the disputing point is how to understand, how to interpret service on site, service. It can sustain, so it avoids the main issue. So it seems that it has dealt with the client, but substantially it didn't settle the disputes. So they just send letters to request a clarification of whether the service is physically to service on site or can be serviced remotely. So this is a flaw from the perspective of the institute. You know, you understand the issue of disputes. So you should do it. You should write the opinion, the key issues of dispute. And the last one is inconsistency of logic. It is a small mistake. If you read carefully, then you will find it. For example, the validity of the contract. The court thought that the applicant don't have credibility of the engineering construction, so that the contract is invalid. But however, on elaborating the damages, it writes that the criteria standard of the damage is reasonable, it should be sustained. So this is a logic mistake. And also, I'd like to talk about the application of law. So most frequently met is four aspects, 4 points: the wrong application of law, and also to use the laws which are not suitable, applicable to this case, and also expired law or the application of foreign law. So we have some trainings previously for the application of law for the judicial review, because previously it has judicial reviews for the wrong application of law. It is one article to revoke the arbitral award. But however, it will impact the quality of the arbitral award. So in recent years, we have updated of laws, for example, civil code, our new civil code, and changed many of the judicial opinions, rules, and the other binding legal regulations, so that if we do not update our legal knowledge, don't know the opinions, latest opinions, it is very easy and also risky to make arbitral award. And in the past 1 or 2 years, many of the problems we have seen, that is mortgage or in lieu to the outside parties, that it requires shareholders agreement that in bona fide, it is in good faith that however, they are referring to the previous Article 16 of the company law. So this is a problem of not updating the legal knowledge for the mortgage. And another one is the priority rights of the construction.
Second problem regards the priority of compensation on constructions. In practice, there will be problems. What is the time period for the payments due if there is a contract? Shall we follow the contract or shall we follow the new payments terms in the new agreements signed by both parties? An extreme case is that when there is agreement on the new payment terms and it has passed the legal time period, so that period has passed, shall we decide on the first period agreed upon? How do we understand the legal interpretation and how do we understand the contract? So we need to clearly understand the interpretation and new laws. The third change is to the date of the rescission of the contracts in the past. If the parties claim to resist the contracts, even though there is no date, we will deem that the contract has been cancelled. But with the new civil code, it clearly provides that there is a change. We need to affirm the problems of contracts. The date of the service of the notes in arbitration, that is to say, the service date of the notification can be deemed as the date of the rescission of the contract. So in practice, we need to make changes. If we affirmed the cancellation of the contract, then we need to negotiate on the dates of the service of the notification. Sometimes it is very difficult to determine the dates. For example, the materials may be refused, they are not accepted by the parties. How do we judge on the dates? We may have our own way, but can we write down the dates calculated by our own method? So this is a question that we need to consider. Another question regards the right to cancel the contracts for the breach. If we add article in the contract that breaching party has the right to cancel the contract, maybe that will be more beneficial to the parties. Another question surrounds the subordination of the collateral in our practice. The responsibilities and liabilities for the breach of the collateral. There is a change on the law, so we need to change our practice. Another problem that we encounter is that before the enactment of the civil code, in the pledge, in the mortgage contracts, according to the pre-existing law, the validity of the mortgage when the collateral is transferred upon the consent of the mortgagees. How do we affirm the validity of the mortgage? Now, with the Supreme Court's case and the interpretation, there is a clear stance. Civil Code provides that when the transfer of the mortgage, then the validity of the mortgage will continue irrespective of the consent of the mortgagees. Can we apply the new law? In the past, the contract provides that the validity of the mortgage will be lost once the collateral is transferred. So how do we handle this issue? The risk is whether we need to affirm the validity against the third party. The buyer, in this case, we need to understand the opinions of the buyer. In most cases, when it is against the third party, can we apply the new law? This is the case where we need to balance the interests because there is no clear provision in the law. There is just some principles. So for arbitrators, we need to make comprehensive research in advance and then balance the interests of different parties. Then we need to avoid excess arbitration and insufficient arbitration. One is negligence excess arbitration, which means that we have negligence, the arbitrators have negligence and arbitrate on matters out of the scope of the claims. But this is very simple. We can negotiate and communicate with the parties. Another problem is the excess arbitration with awareness. I'll give you an example. There is a recent case in which there is a wealth management dispute. The claimant claims the respondents have breached the contract. So the claimants asked to cancel the contract and ask for the investment to be refunded. So the refund of the investments and the liquidated damages as agreed upon in the contract. But the arbitral tribunal thinks that the contract cannot be cancelled, but the respondent has breached the contract. So it asked award damages to the claimant. In the arbitral award, the arbitral tribunal award the damages to the claimants. When we're reviewing the award, our secretary finds that the claimant claims to be the investment to be refunded after the contract is cancelled. But now in the award, the tribunal asked the continued performance of the contract and asked the respondents to make damages to the claimants. So the secretary asked the tribunal to supplement the procedures of the arbitration. For example, to ask the claimants to add the claim. But the arbitral tribunal do not think that he has excess arbitration. The claimants ask for 1 million yuan, whether it is of damages or investment refund. We have supported this claim, whether it is of damages or investment reforms. So this is an example of excess arbitration without awareness. That is to say, the arbitrators do not think themselves have excess arbitration, but this will raise controversy. This is at risk of excess arbitration. Excess arbitration is reflected in the excess arbitration in terms of compensation and the excess arbitration in terms of the grounds or claims. Most of the excess arbitration is in this regard. The grounds of the award exceed the basis of acceptance and the scope of hearing. For example, the parties have signed 5 contracts, but the ground is the most recent ones instead of the prior 4 contracts. But they submit the other 4 contracts as evidence. The arbitral tribunal can the arbitral tribunal cite the other 4 contracts directly in the arbitral award to affirm the legal relationships between the parties? This involves our terms of reference, and this involves the scope of the case hearing. We must think about these issues very carefully. The last part, the main body of the arbitral award. Based on the opinions, we make the final decisions on the claims. This is the key part of the arbitral award. We just use plain language to write down these parts, and this is of most greatest concern to the parties. This involves the outcome of the decision, whether you support or refuse the claims of the claimants. Hainan courts, will they have different standards when recognizing the arbitral award? In Beijing courts, they just read these parts, the main body of the arbitral award. The courts sometimes overlook the other parts of the award, but just read the main body of the arbitral award. They just read the main body. So against this backdrop, most of the cases must be enforced and recognized in different courts in different jurisdictions. So we must be very careful in writing the main body. We must consider different risks. First, the main body shall be well targeted. I will give you an example. Well targeted means that the outcome shall target the claims and counterclaims item by item. No excess arbitration, no insufficient arbitration, and then it shall have uniqueness, which means that there is no unambiguous or difference in the language you use. If you use language that is ambiguous in meaning, then you need to replace the language. And the main body should be definitive. For example, you need to list a definitive payments body, payments contents, and payments terms, no conditions attached. Why? In the past, in some cases, we have conditions attached to the payments. For example, there is sales contract disputes. The contract provides that the payments shall be made upon the acceptance of the goods and with the invoice. But there is no priority given to the payments and the invoice. It just provides simultaneously upon the receipt of the payments and invoice. So there arises a dispute. The arbitral tribunal does not support the claims. So in the arbitral award, the arbitrators write down that the respondents shall make payments within 7 days from the dates of the invoice. So there is a condition attached, and the claimant agrees upon these conditions. But beyond our expectation, when the invoice is issued and delivered, but the respondents refuse to take the invoice, and then the claimant apply to the courts, and then the respondents plead that we do not receive and accept the invoice, but the claimant says that the invoice has been delivered, but the court says that I cannot make judgments on this situation. The refusal of the acceptance of the invoice, can it be deemed as a breach of the contract or the breach of condition? The court returned the case to the arbitral tribunal, to the arbitration. The arbitral tribunal thinks that we have come up with the award. So the ball is kicking back and forth between the courts and the arbitration tribunal. And then the parties are not satisfied with our service. So you must be very careful when you attach conditions in your arbitral award. You must consider the risks, potential risks. You must consider when you attach conditions to the payments, whether the court is willing to make judgments on the condition.
那么在拆解主文部分常见的问题呢有这么几种，一个呢
In the main body, there are some frequent questions. First, the feasibility of the continued performance. If the parties claims the continued performance,
继续履行的内容不明确的话，是不具有可执行性。
if there is no clear provision as to the continued performance, then there lacks feasibility. When we are handling the case, if there is a claim of continued performance, we ask the arbitral tribunal to communicate clearly with the parties whether the contract is valid or not, whether there is feasibility for continued performance. Second problem is as to how to write the obligations for delay of performance. Shall we write down the obligations arising out of the delayed performance? For example, shall we write down the payments of damages for delayed performance? Or we just write down the laws involved? We suggest that you do not need to write down the provisions in the contract again in the arbitral award. Another problem is the attached conditions, and then the distinction between refusal on procedure and refusal on merits.
如果是关于某个具体项不属于审理范围，就写关于申请人某项仲裁请求的申请。
You can write down that refuse the claims of the claimant or refuse which claims of the claimant.
那么这个看几个错误的一些事例。第一呢是
I will give you some examples. First, here is an example. The respondent pays 40,000 yuan in double of the down payments to the respondent, to the claimant. This is ambiguous.
这个风险在于什么呢？就是合同约定的房产到底是哪个房产？它需要
So, what is promises, or it should look at the contract, and the enforcement judge will not look at the previous contract. So you should write it very definitely at which road, the number of the road, and also, for example, a piece of lot of land, then the place, and so that's to attach a list, so that as an attachment for the award. For example, attachment 1, attachment 2, attachment 1 will be attached. And the third one is that after confirmation of breach of the contract, pay the $1 million damage. And the third part is personality and the language. So arbitrators, compared with the judge, it has specialties, special characteristics. Judge are specially trained and many internal standards. So judge, the formalities are very stereotyped. However, arbitrators, a variety of background from all walks of life, lawyers, scholar, entrepreneurs, civil servant, and the other walks, other professions, a variety of backgrounds. So we have some criteria so that to make it in good formalities, and also legal language. But however, should according to different cases and also arbitrators. So respect the language use of the arbitrator We respect your style, different style. However, some of the requirements that you should have a neutral and fair position, and neutral attitude, and also a neutral wordings. That, for example, there's no reason or no evidence for the applicant, for the defendant, that the styles is criticized one side or another side, that you should. So we want the arbitrator to add it. So what is your considerations? Arbitrator replied, I want to educate the young lawyers how to practice, how to serve the client. So this is the arbitrator's feelings and his attitude. However, this is not good for the recognize and acceptance of the disputing parties. Let's look at some examples so that some of the writings. The applicant on one side is claiming the invalid of the contract, but however, on the other side, proposed for the cancellation of the contract. This is a mixture of the mind and lacks basic legal knowledge, and this may irritate the applicant, so that they will go to the court and to apply for the revoke of the arbitral award. And they spent 3 years so that I received the applicant that. So we have very famous arbitrators, and also I communicated with the applicant. For the applicant, do not irritate them. And also for the arbitrators, that you don't have competence to judge the lawyer. They thought that, so that do not write these emotional language. And also another saying is that according to your behavior performance during this arbitration process, we do not support the claim for legal fees. This is not a very good writings. And also the applicant submitted the so-called evidence, So you do not need to write like this. You should say it in a neutral way. And also, for example, that you do not comment on the competence ability of the lawyers or the applicant or the defendant. And the fourth part is some of the skills for the draft of the awardings, that 3-in-1 effort, I call it. So the political effort, social effort, impact, and also legal effort, the different effect, but 3-in-1 that we will consider. So most of our awards are domestic awards, that it will be enforced in China, so that we will consider that the environment in China, so that the social impact or political impact we will consider. That on one side, to avoid the cancellation of the award or non-enforcement of the arbitral award, and also to reduce the probability for the complaint and also the criticize or the disagreement. And because the arbitration law, Article 7, it says that to resolve the dispute fairly and reasonably, according to facts and also according with the law. So how to consider we have summarized the following points that to fully consider the policy impact is because of the Chinese characteristics that some of the policies may even overriding the laws. So how to application of the law, balance the application of law and the application of the policy. And we were not in confrontation with the policy, especially that this award will be enforced in some other places. That, for example, P2P, small amount finance problems, finance companies that the P2P company, that the online finance companies have been cancelled by the government, by different, and so the defendant submitted the reply for of the government reply that we will not do the share transfer for the P2P company. So the government reply to a designated company don't have legal effect, legal rights. So how to for example, the policy has forbidden this one. Then to change the shares, to transfer the shares, that the relevant authorities told us that it is forbidden. So how we deal with that? So arbitration court, the arbitration institutions, you don't know the intention, and so we consider the enforcement of the contract. So we will reboot the contract, but we will not interfere the legal rights of the contract. And also for the real estate developers, the delayed, postponed certification of the real estate rights, so that the developers, so many of the developers that the government authorities will not let us submit the evidence that it is the government authorities institute will not receive our applications. So what is, you can submit evidence, but however, they don't know the realities of the Chinese practice, that many of the Chinese policies is oral instructions. There's no written policies. If you practice in this field, in these industries, you understand this. So there's no evidence, written evidence. However, there's a high probability that you will not write in the draft, but you can write some background so that can reduce your liability if there's a liability. And both sides satisfy that. And also for criminal cases, if the case is related to criminal cases, and also related to large majority of people, and also government and the state-owned enterprises, for the judicial research report issued by the Supreme Court, they have summarized arbitration cases which has problems. And for these key cases, that is, the cases related to the large population, and also related to government and related to state-owned enterprises. So for this kind of cases, be cautious. And also the criminal cases, that if there's reasonable doubts, if the case is related to criminal proceedings, however, the arbitration court the arbitration institute, can they consult with law enforcement agencies so that we will reduce the political and the social risks, and also the stability, and also, for example, corruption, and also loss of state-owned assets. These cases are sensitive. So the arbitration court will that not only stick to the law, but also consider the background, so that we will look at that for the social stability.
Third, you must conform to the industry practice. When you give your arbitral award, will it discourage or encourage the innovation, or will it be against the industry practice? This is a factor that we need to consider. We need to consider the existence and innovation of the companies. So we must adopt the principles of flexibility and encouragements of trading. Fourth, we need to respect the autonomy of the parties' will. As long as those wills are not against the third party's interest and law, we do not deny the validity of the contract or a certain provision of the contract. We find that there is an anti-commercial bribery clause in the dispute, and the damages is as high as several tens of millions of yuan. The arbitrators does not want to support such a high compensation and damages, magnificently exceeding the scope of the breach of the contracts. But this behavior is against the autonomy of the parties' will and against the contracts. The fifth, to maintain the existing social and economic relationships stability and do not resolve the existing social and economic relationships freely. There is a case involving Hebei real estate developer. 10 years ago, this developer has issues surrounding the existence of the companies. The legal representative of the company was put into jail, and the company is in financial difficulty. To introduce new shareholder, they find a developer in Beijing and sold over 80% of the ownership to this developer at the cost of 2 billion yuan, and most of the payment is made to the respondents. There is a default of 200 million yuan. This Hebei developer developed a new project after phase 1 and phase 2, and there is a phase 3 undergoing 15 years later. This claimant's legal representative has completed his sentence. He said that the considerations at that time was less than the market value of his company. So he asked for the cancellation of the contract. But there is a time limit. He cannot find a ground because there is damages of 200 million yuan that is not paid by the respondents. The respondent says that because you do not satisfy the conditions, so we do not make the payments, and then the case is submitted to the Beijing Arbitration Commission. The arbitral tribunal, in the preliminary award, to my surprise, he is also an arbitrator with HIAC. He is not in these sessions. He thinks that the contract should be cancelled because the respondents fails to make up the damages of 200 million yuan and failed to make the payments with the remind of the claimants. But the subject matter involved is 20 billion yuan, and phase 1 and phase 2 have been sold and completed. Now you want to cancel the contracts. If you cancel the contract, then the stake is very high, but the arbitral tribunal insists on his opinions. We asked 3 experts to give opinions. These 3 experts take the view that the contract should not be cancelled. After the first review of the experts, the presiding arbitrator do not accept the expert's opinion. And then we organized the second expert review with another 3 experts. These 3 experts also take the view that the contract shall not be cancelled. And then the arbitral tribunal accepts this opinion and asks the respondents to make up the damages of 200 billion yuan to continue to perform the contract. So the point at issue is only the willingness of the payments. The 5th consideration is to give weight to the party in disadvantaged position. This is also in consideration of the unique conditions in China. Though we must maintain impartiality, if there is a party in prominently disadvantaged position, or this party do not hire lawyers or do not have understanding of the legal knowledge, in such situations, we do not refuse the claims of such party freely. We are not learning the spirits delivered by the 20th Party Congress. So in arbitration, we also need to learn how to better serve the parties. We must have sympathy, not to handle the case strictly. When possible, with appraisal, with test, with partial arbitration judge award, we can guide the parties to resolve the disputes and also explain the opinions clearly, or help the parties in disadvantaged position to clearly demonstrate or explain their opinions. The 7th consideration is to consider the feasibility, the enforceability of the arbitral award, and consider the subsequent remedy or relief available to the party. When I review the case, if the claimants are not refused in whole, I will ask whether there is subsequent relief and remedy. There is a case on the disputes of fund. The respondent, the claimant is limited partners of the fund, asking to replace the manager of the fund. He has contacted other limited partners and organized a partners meeting, which agrees to replace the
一个
manager.
合伙人的会议的内容。但是基金管理人不干了，说那不行，说你没跟我
But the
讲，
manager
是吧？
refused
说
to
你没通知
resign
我参加。申请人说我通知你不
because
来，
he
双
is
方就产生了
not
这个很大的
in
纠
the
纷，告诉
meeting.
仲裁。
Then there is a
仲裁员经过
dispute.
审理之后呢，又做了专家
After
咨询，最终意见
arbitration,
的是他
we
觉
have
得
organized an
不支持会
expert's
更好。
opinion.
那当时我们就问他，你现在不支持，
The arbitral
但是将
tribunal
来
refused to
他有
support
没
the
有其他的路径
claims.
来更换这个管理
The
人？他有没有
Then
途
we
径？还要
ask
怎么做
whether
才能达到认为的
subsequent
正
relief
常标
and
准？
remedies are available to
对
the
吧？那仲裁
claimants.
员会
If
去思
you
考了很久，
refuse
然后
the
给我们写了一
claims,
个基本的一个意见。
then the
我
arbitral
们为什么要
tribunal,
他这个意
the
见？是因为
arbitrators
这种案子从
considered
社会效果角度
further
来讲，当事人很可能
why
会
we
跑。
asked
在当
to
事人投诉的
review
时候，如
such a
果我们和他
case
沟通的时候，我们告诉他你后续怎么来完善你的请求和主张举证的路径，有哪些救济的
because we
措
need
施，
to consider if
对
there
于
is
当事人来讲可以极大的
subsequent
缓解
relief
他的
and
压力。
remedy
他
available
可以很
to
容
the
易的会考虑
claimants.
哦，那我可能现阶段不行，我确实有一些瑕疵，但是我后续只要补救了，
Then
有
the
机会
claimants will
他
be
就不会那
aware
么愤
that
怒了，不
maybe
会
there
对
is
那么对他。
deficiency
增
with
加
the
裁
current
决的
evidence,
社会效
but
果。
he has
但是如果
other
你不知道
relief and remedies.
无法解决的时候，他就会认为我的权利再也没有空间，
If
他就
you
会
do
把
not
所有的，
communicate
就是我们
with
很
the
简单，他会
parties
把所有的
on
怒火
the
和所有的
subsequent
压力全部
remedy
释
and
放到你
relief,
这个机构，
then
释放到你这个
he
仲裁局，
will
会增加我们大量的维稳的风
impose
险。
all of the pressure on you. Then you will put
第
your
八个
arbitral
呢是
award
明
at
显没
risk.
有明显超出双方当事人的心理预期。
The eighth consideration
这个怎么来？
do
那有
not
的老师会问，我怎么知道他的
exceed
心理预期是什
the
么？
mental
这个就
expectation
是
of the
我们
parties.
内部
You
评
may
估，
ask, how do
所
I
以有一些
know
技巧和策略，
their
为什么
mental
在庭上
expectation?
建
There are
议大
some
家多做
skills.
调解呢？做调解的目的不仅是为了达成
That's
调解，
why we
还有
suggest
试探
you
双
can
方的
adopt
心理预期
mediation. Through
和态度风
mediation,
险。
you can
你如果做过
explore
调解之后，
the
再
right
去解决，
lines and
你
the
的
mental
平衡内容
expectation
里
of the
就有很
parties.
多手段和
After
措施，
this
你心里
process,
是有数的，
when you
知道
conduct
双方的平衡是
arbitration,
什么，
then
所以你才
you
对结果
can
不
know
能跟
the
双方的当事人预
lines
期
of
有
the
明显的冲突，
parties,
非常明显
and
的冲
your
突，这也
arbitral
可能
award
导致
shall
裁决效
not
果不
be
好。
against or not
第
exceed
九
the
个呢是做好
final
当
the
事双方
line
之
of
间
the
的利益平衡，
parties.
善用一些法律
Another
规则，包括
consideration
过失
is
相
to
抵、损
balance
益
the
相抵、
interests of the
减少规则
parties.
等等。那我举个很简单
For
的例子，
example,
大家在实务当中会经常碰
the
到，
net
有的时候违
damages
约
or
责
the
任过高，
compensation shall be
但是被申请
corresponding
人
to
又
the
没有提违约
loss.
抗辩，说违约金调解的抗辩，仲裁员觉得那我是不是可以不主动调呢？但即使
Sometimes,
吧，觉得
in
违约
some
金太高
cases,
会有风险。我们可以给大
the
家举个真实
arbitrators
的
may
案例。
think that the
这个我们
damages
在大概5
as
年
agreed
前裁了
upon
一个
is
被申请人是南京的一家公
overly
司，
high.
申
For
请人是
example,
北京
there
的。
is a case.
那么申
The
请人要被申请人承
claimant
担的
is
大概
from
是1200 万
Beijing,
的违约金，本
and
金
the
只有300
damages
万。
is as high
所以我们在核
as
稿的时候，我们建议仲裁庭的那个大幅
over
调减这个
10
违约金。
million
那
yuan,
仲裁员这
but
个
the
也是北京的一个
principal
很
is
资深的
only
法官，
3
退
million
休法
yuan.
官，他非常
The
支持你做这
arbitrator
个
is very experienced, a
说
former
被
judge.
申请人当时确实也没有来，说这个
The
被申请人没有
respondent
提，
is
所以我们
in
这个裁是没有
absence
问题的。法律上肯定没问题，因为我们觉得
because
他是
the
一个资深的法官，觉
respondents
得业内
do
人士
not
也都是这个意见，所以我们
issue
才
their opinion. So the
这个法律
arbitrators
日以后
think
呢，
that they
去年的
can
就被
support
被这个南京的法
the
院、南京中院呢给判了
claims,
不
but
行，理由
the
就是说
arbitral
以公共
award
利益为
is
由。
refused by the
他这个我
Nanjing
们在公共
High
利益肯定是不
Court
对的，
on
但
the
他可能
grounds of
找了个理
public
由，
good.
他实际上就是他跟我们打电话沟通的时候，就是说他觉得这个违约金太高了。
The High Court
仲裁
telephoned
庭不能
us and
简单的
thinks
依据
that
合同契约
the
自由，仲裁员还要
damages
主动
is
介入
overly
做一下
high,
调解。
though the
其实我后来
damages
的研
is
究就是
agreed
说，
upon
即使
in
我
the
不愿意主
contract,
动提，
but it
我
is
还是有很
apparently
多理由
overly
去求
high.
证。就是我说我们要善用一些法律手段，
So we
促使
need
双方的利
to
益不至于受损
leverage
害。
some legal
最后一点，
tools.
注意有关联案件在
The
先裁
final
决，法院的
consideration,
立
we
案
need to
保持一
give
致。
attention
至少
to
来
the
讲，
relevant
表面上要
case,
一致，不要
prior
出现
cases,
实质上的分歧。
and the
这一点也是我们
consistencies
所说的，
with
我们在
the
裁决的时候应该
litigation
机构
cases.
多沟通，多做
We
检
need to
索和考虑。
communicate frequently
在关
with
联
the
案件在先裁
institution
决，机构也是
and
非常清
to
楚的。
read
法院的立
other
案，机构
cases,
也可能
in
知道，
particular
即便不知
relevant
道，
cases and
你自己
prior
做检索
cases.
也是能够发现的。
We
我们
can
基
do
本上跟这个
search
精神
and
和内在保
index
持一致，可以大
ourselves,
幅降低我们仲裁员的风险。
inquiry after the institution so that we can reduce the risk of our arbitral award. Even though the award may be refused by the courts, we can revoke other cases with similar other judgments or other awards with similar cases. So much for my sharing today. I've shared with you my experience in how to write the arbitral award. And any opinions and comments are welcome. Thank you. Actually, you do not finish your PowerPoints, right? Do you want to finish your PowerPoints, Mr. Dean? If time permits, okay. Yes, you can continue your presentations. We are more than willing to hear from you. We enjoy your lecture. You can continue your lecture.
我前面提到了一些考虑的因素，那么中代田有些什么策略？就是说在具体的
What are the strategies?
我用哪些方法来控制呢？
What are the methods to manage the quality of the arbitral award?
我可以控制的因素。
What factors can be controlled by the arbitrators? And what rights available to us as arbitrators to deliver better outcomes? There are three factors. First, the claims, procedure, and the grounds of arbitration.
So, for the claimant, you intervene too much if you, so you can only elaborate or to, it's not compulsory, so only introduce. So, but for the other two, procedure and reason, if the award will not be challenged, and also to better solve the disputes, we can emphasize and pay special attention, pay more attention to procedure and reasoning. For one party, and it's fair, it's unfair, it's severe unfair, or we may feel that in some of the cases, they are urging or send to ask the leaders to intervene, and also, for example, related to criminal procedures, then we issued the final award, and then we find if we just issue the award in urgent, then there may be problems. We have two cases I like to share with you. That a financial institute and another person, another side, a party is legal, is natural person. So that the finance problem, finance platform is involving criminal procedures. So I want the arbitration to pause. So we want to wait for the court. And we consider it's just a two natural person, so no other people, it's not a majority of population, then there's not so much problem. So this is stand. However, this two person, different measures to go to Beijing Finance Court. So they tell us, they suggest to hear again, so in this case again, for the procedures, you are too urgent. Have you consult the public security, the police? So the evidence is not enough. So we're going back for the procedures. So I want to speak to you that so one party is urging you to issue the award. So you should first make sure of the facts so that not being interfered by the one party. They, if why you file the case in urgent time for the finance institute, what do you want? You want to settle the debt, or you want to get rid of the liability for the staff? There are some considerations not reviewed to the arbitration court, so that, and also consideration from the attorneys, lawyers. For this is a strategy. So the arbitrators, arbitration court will make sure and think second, think twice. So the judicial investigation or false litigation, then we will do that, so that to postpone the time, so as to seeking the truth, or some of the intentions will be reviewed, or cooling down, so that to find more truth, and also procedurally to protect ourselves. So that expert consultation, fully going through the internal procedure, and then we make final rewards to use procedures to protect ourselves, and also claim procedure, and also reasons we can balance in the reasonings part. For example, if you emphasize on one side, you have empathy for one side, then you can write something be reflected in the reasoning part. And also, for example, one side in honesty, in good faith, to adjust the damage, so that you can speak and you can write in the reasoning that, however, they have seen that the court has considered our claims, our arguments, so that it's easy for them to accept. And also the share of burden of arbitral fees, so that another one is liability in compliance with mistakes, even if that one side is winning, that the winning party can also burden some amount of the arbitral fees. But before the enlargement of the damage, if you have liability, then the arbitration fee can be allotted to them. So the losing party, it can compromise the conflict, and also can report to his leader. The arbitration fee, very small amount, however, it's symbolic, and also can direct the following road for dispute resolution, for the finance management disputes. We have many communications with the other arbitration institute, that for the finance management cases, it's still in the settlement process. So the loss is not definite. So you want to sustain, and what is the loss? So if for Beijing Arbitration Court, high charge of arbitration fee, so it's a 70,000 threshold fee. So, because the indefinition of damage will rebuttal the application. However, almost 20,000 arbitration fees, so they have disagreeing opinions, complain. So I cannot sustain because the settlement is still in process. Damage is not definite. However, you have also not fully comply your liability of complaining in time, so that we just use this reason. And also the burden of arbitration fee. We use this strategy so that they know the following remedies, to wait some time so that to use that. And also the judging philosophy, how to serve our purpose. For example, back-to-back article or batting article. So in litigation, they just merely say it's invalid. It's, for example, the buyback articles for a company. However, the evolution of the judging philosophy that to respect freedom of contract, freedom of intention, that the consideration, price, back-to-back article, we don't know the real situations at that time. We want to make it invalid 6 or 7 years ago. Many of the construction companies, China Construction, China Rail, that our judgment is not observing the commercial practices, and we have an expert, we have a meeting to invite them to speak. Some of the enterprises, they have, if they don't have back-to-back article, then they cannot get this project. Then they will find those who accept this article. You cannot just give up these opportunities, so that if you accepted it at the negotiation, at the competition side, you cannot just object to that or say it is invalid for during the settlement dispute process. However, it may damage one party's side, that after, for example, after 3 or 4 years, they don't get money. They're going to, for example, you have met and fulfilled the condition. There's a very strict procedures. So back-to-back article, have you claimed your rights in time, immediately? If not, then you don't have a defense right. You cannot just deny the validity of this article, and also to consider the fairness of the results from the perspective of fair, or you don't fully satisfy your obligation, and also to consider the satisfy, and also to satisfy and the expectations, so that the risks and benefit balance. So high risk, high benefit. So this is also a comprehensive thinking of the judging philosophy. And also the suggestions for the arbitrators, for the feedback from the Arbitration Institute. So what kind of common questions? So for the relevant cases, group arbitration, group litigation cases, so the coherence and expectation. We sometimes afraid that they have very independent. They thought that the other arbitrators are wrong. We have almost 600 cases. So we'll find a university teacher, simple case, and previous precedents. So I issued 10 cases to this teacher. So he thought that the 10 cases the applicant will lose. So he told us that I should observe the consciousness of the arbitrator. So, as a dispute resolution institute, maybe scholarly it has different opinions, but in practice, there's no dispute. So, for these relevant cases and group litigations, we will observe the consistencies and expectations. Your different interpretations may have huge impact for social stability. So for this kind of cases, pay special attention to.
If we find that the preliminary evidence is not sufficient in preliminary draft, for example, I have read over 10,000 cases, and we have experience with different categories of cases. But for arbitrator, you yourself, you may have experience with just 1,000 cases. So if we deliver opinions for your reference, our aim is that you can have more comprehensive homework and more comprehensive research. The third suggestion is that we think that the reasoning of the arbitral award is not sufficient and cannot persuade me. If I cannot be persuaded, then I think that this arbitral award cannot persuade the parties. Then how can I protect the interest of the arbitrator? And how can I say that the arbitral award is sufficient in reasoning, protect the public good, protect the interests of the parties? We must make sure that we do not have contradictions between reviewers and arbitrators. Another factor is that we think that the arbitral award may produce bad social outcomes, and there may be unexpected risk. And how do the arbitrators treat the reviewers' suggestions? First, I suggest that you need to take the reviewers' opinions reasonably. Though the society is complicated, we cannot ensure that everyone has impartial view. But we still suggest that the arbitrator should be reasonable when treating the reviewers' suggestions. So there is a case that the reviewers find that the arbitrator's opinions contradict with him. And there is a case where the presiding arbitrator thinks that the co-arbitrator's opinion contradicts with him. So he questions the quality and professionalism of the co-arbitrators. So we cannot freely judge the personal quality of other arbitrators or other reviewers. And we need to understand each other. The institution and the arbitrators need to understand each other. We are in the same line. We want to deliver good service to the parties. Though arbitrators are independent arbitrators, and arbitrators' views and opinions are final, But if you cannot deliver a high-quality arbitral award, then it will impact the quality and credibility of the institution. And then I suggest that we need to have a bigger picture, set aside our personal stance, and we need to explain the facts item by item clearly. And we need to explain any doubts of the other party, reply to any other party's considerations and doubts. If you do not reply to the doubts of the institution, then in the future, the institution may not be willing to nominate or appoint you as the arbitrator. And the final, the opinions of the arbitrators will prevail and be final. Sometimes the institution and the reviewers do not participate in the arbitration themselves. Sometimes we cannot feel the expectation and mentality of the parties. So we believe in the arbitrators because it is arbitrators who take part in the whole proceeding. We all want to deliver good outcomes. We cooperate with each other. We are not against each other, and we do not need to argue with each other. Maybe I'm wrong, but you need to reply to our doubts and explain clearly. After such back and forth, only after such back and forth, our arbitral award can resist any test. So we need to understand each other. We trust each other. Actually, the pressure of the institution is very high because it takes long time for the arbitration institution to review the arbitral award. And I also suggest the reviewers with the institution to review the arbitral award carefully and prudently. For the institution, we do not put forward opinions freely or without prudence. We don't break the mutual trust between the institution and the arbitrators. Only in this way, we can live up to the expectation of the parties. Thank you. Thank you for your listening. So much for my sharing. Thank you, Mr. Ding. I strongly agree with your opinions and suggestions. I want to follow your final points. I want to add that you just mentioned that when the reviewer put forward doubts to the arbitrator or the arbitral tribunal, the tribunal and the arbitrator must clearly explain and reply to the doubts one by one, because different arbitrators have different characters. Some are willing to communicate with you if you have doubts, but some are quite self-confident and reluctant to explain their decisions and opinions, and do not reply to the doubts of the reviewers or the institutions. In this case, as you said, that the pressure is very high for the institutions. So we hope that we can have good communication between the institution and the arbitrators. When there is a doubt from the institution and reviewers, we hope that we can have sufficient explanation and communication. Arbitrators can fully and sufficiently express his or her opinions to clear the doubts of the institution, because sometimes maybe the institution fails to see the case from different perspective. Mr. Ding, in his presentation, has demonstrated his professional level as a senior arbitrator who has received over 5,000 arbitral awards. I think it is a perfect integration and combination of practice and theory, and you have given us many details and clearly explained why do we take such approach, the reasons behind the scene, and you've given us many examples, many cases in practice, and candidly explained how we deal with the case and award in Chinese conditions. And you have also given us the experience of Beijing Arbitration Commission. Thank you very much. Your lecture has touched upon each and every scenarios in these themes. You are quite an outstanding arbitrator. Next, we will have the second lecture to be delivered by Zheng An Tony Zhang. He is an arbitrator with HIAC, and he is the vice director in Shanghai office of HIAC. He is also a senior partner of Xie Law Firm Shanghai and Shanghai part-time professor and tutor of Shanghai Maritime University. He is an expert URJH. He is also a counsel to entrepreneurship. He is also a member of the expert committee of the CTEC and member of the Expert Consultation Committee of Shanghai Department of Justice. He himself is an arbitrator of many world-renowned arbitration institution. His theme today is arbitrators' conflicts of interest and handling rules. Mr. Zhang, good afternoon. Mr. Zhang, please unmute your microphone. Please wait. Mr. Zhang is resolving some technical problems with the computer. Please wait. There are problems with my internet. Can you hear me? Yes. The internet is not very good with the computer. I will change to my mobile phone. Please wait. Am I clear now? You can continue. We will watch to see whether the sound is stable. We can read the PowerPoint and we can see you on the screen. Sorry for the technical problems. The internet in the office is not good, so I changed to the hotspot of my mobile phone. Thank you. Thanks to HIAC for inviting me to deliver a lecture today to communicate with the fellow arbitrators, in particular on the disclosure of arbitrators and how do we handle the conflicts of interest. As time is limited, I will deliver my speech from the following perspective. Can you see my PowerPoint? Yes.
这个 PPT 是正常放吧？
好，你点一下播放啊，对，OK，好。
You can click the button play.
那这样，那我想讲一下，就是说这个讲几部分内容啊。那么首先呢，就是仲裁员呢是在仲裁这个程序过程当中啊，是最重要的一个环节。
The organization, the establishment of the tribunal is the most important process in the arbitral proceedings. Arbitrators plays a paramount role during the arbitration proceeding. Just now, Mr. Dean has shared with us how to write the arbitral award. Before writing the arbitral award, all of the processes in the proceedings involves the arbitrator. So the credibility of the arbitrators and whether the arbitrators can give a good impression to the arbitrators during the proceeding is of critical importance. And this involves the impartiality and independence of the arbitrators. That requires the arbitrators to make necessary disclosure, and we need to handle well the potential conflicts of interest. I have experiences with foreign institutions and domestic institutions. I have experiences with arbitration cases and cases to decide on the impartiality of the arbitrators.
这个申请了这个中国仲裁法学研究会这个仲裁员信息披露和利益冲突的这个课题。那么这个课题呢，
And to date, our lecture is on. We have applied for a lecture titled as the handling of the conflicts of interest. This lecture is recognized as an outstanding lecture, and I will share with you some of the issues we identified during that lecture. Next, I would like to dwell upon the practical problems. Third, the issues with the model law and how do we consider the conflicts of interest in practice.
So today it's a training from Hainan International Arbitration Court, so an exchange platform. So according to the rules of the Hainan International Arbitration Court, to elaborate, to introduce the content, and the next one, the last one, is my suggestions. So this is the content. So the procedures for the submission of application, issue, filing notice, and the composition of arbitration court, and hearings, and also arbitration award. So arbitrators. This is important for the arbitrators. So for this problem, so first of all, the arbitrators, it is a cornerstone for the credibility of arbitration. Why they choose arbitration? So, and also it is also related to arbitration court. But the arbitrators, it is whether it has credibility or selection of arbitrators. This is also consideration, very important one. This is what kind of arbitrator. Arbitration is as good as arbitrators. So any arbitrators, if it's in compliance with the law, it can be an arbitrator. But however, not everyone has a credibility. And during the arbitration, not every arbitrator has professional knowledge. So the professionalism of the arbitrators is very important. So many cases being introduced by the previous speakers. So the theory, practice of the arbitrators, and also and the perspectives are related. So the arbitrator is very important. Because of this, for arbitrator, the independence, credibility are, no matter it's the institute or the claimants and the judicial institute are a very important question. So independence, fairness, the information disclosure, is it comprehensive in time? Then it's very important. So the disclosure of information comprehensively, in timely disclose, then it will lead to the next problem, that is the conflict of interest between arbitrators and between arbitrators and the applicant or the parties. Some special relationship, probably. It will impact the fair and the credibility of the arbitration. So in practice, the following problems. The first one is the stipulation of law is not clear, and then different institute has different practices, different, and our arbitrators, for example, in Hainan arbitration, International Arbitration Court, and in Hainan and also in Beijing, in different arbitration institute. So if it's, and also different laws in different countries, and the institution practice, institution rules. The second one is the arbitrator didn't know or don't know the relevant information disclosure mechanism and how to disclosure. This is what we have discussed and researched on and reflected by arbitrators. Why they don't disclose? Many of the which kind of information should I disclose? And for this information, I have some doubts. I ask my friends or ask the secretary or from the arbitration centers. These are the questions they have. What kind of information should we disclose? This is the problem. And another problem is that the applicant, defendant, and their representing lawyers don't know the information disclosure and also the challenge systems. So we have met many situations. They don't know, they haven't find research on the information and the relations between different parties. However, when the result comes and not in favor of themselves, then they go back to find this information. The incorrect disclosure of the information, or they don't have information disclosure, and they have some kind of special situations, and then go to court, want to cancel the arbitral award. This is a common problem also.
另外呢，就是说这个第4个呢，就是
And the fourth one is
比较有效的
that is
仲裁员的信息披露
how to practice information disclosure
这个
for
利益冲突的这个回
institutions.
避决策这么有效的
What is the
一个机制。 那
mechanism?
么这个呢，也是非
This
常
is
非常
important
重要的一个因
factor.
素啊。那么
So
具体
I'd
展
like to
开呢，
elaborate.
这个具体展开的话呢，这里面是是有的问题啊，这个我
Many
就不展开讲了。
problems. I'm
比
not
方
going
说
to say one by
我们
one.
很多
For
的
example,
这个仲裁机构的
the
仲裁
list
员的名册， 我
arbitrator
们只能
list
看到一个大
only
概的
see the name
这个不同的机构它的做
and
法不一
also
样，所以
different
呢，
practice by
这个
different
不同的名册里
institute.
面的披露的信
The
息啊，
information
有的比较
disclosed,
少，有的几乎就没有。
there's
那么有的
almost
呢，机构相对
no
多一点。 但
special
是呢，
information in
很
some
少有仲裁
list.
机构呢，
But
披
there are
露这
few
个仲
institutes
裁员的
that
这
the
个工作原则。
arbitrators its working
那么我
experience.
们要特别注意的就是说，
So
我们当事人，
the
我们如果
parties,
仲裁员不主动
if
披露，
you
假设
don't
这个案
have
件来了以
active
后，仲裁员
disclosure,
不主动披露，那么我
the
们仲裁
arbitrator don't have active
员的名
disclosure,
册，或者
and
说
also
仲
the
裁
list,
机构的网站上，
the
网
website
站的名册里面没有详细
don't
的信
have
息的话，特别
detailed
是工作能
information,
力的话，
especially work
那么当事
experience.
人呢是很
Then
难查到这位某
the
位仲裁员是否与当
it's
事人之
difficult
间存在着
for
可
the
能的这个
both for
利益
third
冲突的问题，
parties
因为
to
这个信息呢很
research
少。
on the
那么
conflict
有
of
的人呢在
interest.
网上的信息多，
So
有的人
many,
呢
so
在网上
some
的信
they
息
have
少。
informations
那么同时呢，
on
还
the
有
internet,
这
but some
个
they have
重
few
名的情况
information and also the
啊，
same
那
name,
么等等。所以说呢，导
etc.
致这个当事人呢他很难来
It's difficult for
调
them
查到
to
或者说
research
了解
on
到仲裁
the
员的工作
background
信息。那么
of
也
an
就是说，
information of the arbitrator.
所以这个呢是
So
首
this
先呢
is
是这个
the
第一个问题。那么第二个
first
问题呢
problem.
是
The
说，
second one is
我们在国内仲裁的过程当
in
中啊，
China for arbitration.
那么我们
When we
没有要求仲
nominate
裁员呢提交
arbitrator
简历的
at
一
that
个
time,
这样的一个做法。
we haven't
那么这个做法呢
required
在
them to
国际上
submit
呢是
CV
通行的
or
啊，也就是
bio
说，
bio
或者说也没有
informations.
说我一定要
We
说，一定要有什么规定。
or
但
what
是呢，这个
special
国际
rules,
仲裁最基
but
本
for
的一
the
个是说，
international
我要选你做
arbitration,
仲裁员，
if we want to
或者
select
说如
you
果指
as
定你做仲裁
arbitrator,
员的话，那
appoint
么你
appoint
的
you
这个
as
简历呢
arbitrator,
是最基本的，是
your
需要提
CV
供给
resume
这个
is a basic information,
我
basic
们这个机构的这个
materials
案件管理人员。
that
那么这个呢是在主听之前呢，
this
这个
is
是一般性来讲呢
this
是
is a
这个
basic
是要给的，因为不
material.
给这个信息，那
Otherwise,
么我们这个当事人是很难查
how
到
to
你这
know
个很难
how
从别
to
的渠道来索取
research
你仲裁
to
员的
get
个人信
information
息
from the other
所以
channels?
这个呢是我们国
This
内的
is
做法呢，
the
基本
practice in
上是
China.
没有这样的一个做法。那么我建议呢，
I
是不
suggest
是
that
可以这个考虑一下啊？那么在国际
we
上呢，是
consider
很
the
正常的，
practices. This is very
也
normal
便于
internationally
提高我们仲
and
裁员
also
信
to
息的一个透明度啊。
transparent for
那么
the
第三个问题呢，刚才讲了，就是我
information
仲裁
of
员我不知
arbitrator.
道要披露什
And
么，
some arbitrators, they don't know
我是否
which
应该
kind
要
of
披露
information
啊？
should
那么这个呢
disclose
是没有一
or
个
whether it
统
should
一
be
的一个指
disclosed.
引，或者说
There's
这个
no
参考的一个标准。
uniformed
那么第
practices
四
or
个问题呢，就
references.
是说
And
这
the fourth
个
one
仲裁
is
员
that
呢，有的时候呢，他
if
有
we
顾虑，他
disclose
说我
some
如果披露某一
information,
个信息，
then
可能我
it
觉得
will
跟他
lead
有什
to
么
be
关系，但
challenged.
是呢，可能当事人
Or
拿到这个信息
but
以后呢，
if the
他
parties
就
got this information,
恶意的要求你仲裁员
they
可
want
能
you to quit.
那么这个呢也是有顾虑的啊，
And they
因
have
为没
these
有统一的一个
concerns
做法，或
because
者
there's
说统一的
no
指引，所以
uniformed
导致仲裁
practice
员呢，
or
他
guidance.
这个披
So
露的一些
sometimes they are
他认
hesitate,
为可能是
arbitrators are
没有
hesitate
关
to
系的信息
disclose
的时候
some
呢，他
information.
呢是有点顾虑的啊。那么这个顾虑呢，
So this is their
可能
concern
就会
that
就会存在着一定的问题啊，这个我就不说了啊。那么另外
another
第
one
五个
is
呢，就是
that
说，
once
在国内呢，这个仲裁员呢也
if
经
a
常遇到的
arbitrator
问题
has
就
been
是说，
challenged,
哎呀，只要当事人提出回避，
then
那么我呢就主动退出，
voluntarily quit
因为当事人已经对
because
我不信任
they don't
等
have
等。
trust on
那
me.
么这个呢，为什么我把
So
它
I
引列出来
listed
呢？我觉得呢，我觉得呢，这也是一个问题。
this is
那么这
a
个问题呢，可能涉及
question.
到的这个
This
这个
involves
背后的这个问题比较多。比方
many
说，
questions
我们
behind.
仲裁
For
员的
example,
费用问题啊，我本
arbitration
身也
fee.
我们是兼职的，做公益的，对吧？我们一直强调，
We are
那我
doing
也挣不了多少钱。
it's
那么
not
既然提出回避嘛，我也省得这个麻烦，
a
那我
high
就主
pay,
动退
a
出了。
high pay, heavy
但是
paying
呢，
job. So I
这是
just
一方
quit.
面原因。那另外
And
一方面
another
原
one
因
is
呢，
that
很多仲裁员交流的时候也说，哎呀，这个既然当事人已经不信任我
I
了，我干嘛还
the
要再做仲
parties
裁
don't
员呢？
have trust on
那
me.
么我
Why
还
am
是
I
退出
going
的话，
to
会更
continue?
好
So
一点。
it's better for me to quit.
但是呢，就是说这个主动退出问题
And
啊，那
the
我个人觉得
voluntary
呢，
quit is
也是有很多的问题。因为主
many
动退出，
problems also.
我们可以想象，
The
如果
arbitrator
说
withdraw
是首席仲裁员的话，那么你
initiatively
主
or
动退出，
actively if you are
那么
presiding
对这个案件的这个公平公正，假设不
arbitrator
应该退出的
stands
话，那么对这个案件的公平公正的审理本身
if you
也
should
是
not withdraw, but you
也是没有
withdraw
这
on your own
个没有好
decision,
处的，对
then
吧？
it will
那么
impact
假
the
设是这个
impartiality and
编裁选
independence
定
of
你
the
的话，
arbitration.
那么你主动
If
退
the
出， 那么对这
co-arbitrator
个编裁
appoint
也
you
是对这
as the
个对
presiding
这一方当事
arbitrator,
人呢也
and
是
if
不负
you
责任的。也就是
withdraw
说，你
on
主
your
动的退
own,
出，
then you are not
看上去姿态比较高，但是呢，
responsible for
可
the
能也会影
co-arbitrator
响到
who
这个
appoints
某种
you.
程度上这个
And
案
to
件的
an
公
extent,
平公
your
正的审理。因为什么
withdrawal
呢？
will impact
因为这个当事
the
人可能就
impartiality
选不
and
到合适的仲裁
independence
员，
of the
所以
arbitration
说对当事人
because
来
the
讲呢，
parties
他对这个仲裁的
because there may
是
be
否能
no
够公平
other
公正的审理，他本
arbitrator
身也存疑。
available
也
to
就是
the
说，你
party.
保护了另外一方，但是呢，对这
You
一方来讲
protect
呢，他也是
the other
对这个
party.
仲裁
You protect
的这
one
个公
party,
信力
but
呢，
for
他
the
也
other
认为
party,
存在着
you
怀
are
疑。因为
withdrawal have
特别是对
impacted
恶
the
搞的一些
impartiality and
案件，
independence of
是吧？
arbitration.
那
In
个
particular,
提出一次
if
让你
the
回避，提
challenge
出
is
2次让你回避，提出3次让你
unjustifiable,
回避，那么这
for
种情况
example,
呢，
the
实际上
parties
是也是
make
这个不实的这个
3
存在的。
or
那么这
even
样的话就
4
导致另外一方
applications
也会导致
on
另外一方，我把它有
challenge,
提没提，我就给你提，我就给你恶搞。所以这个呢，我觉得呢，也是
then your
影响到仲裁
withdrawal
的这个公
also
信力的啊。
impacts the credibility
那
of
么第6个问
arbitration.
题呢，就是说这
The
个仲
sixth
裁员呢是
problem,
不了解其他仲裁员
the
的体系，
arbitrators do not
那么他
understand,
也无法
do not know the
确
other
定是否有利益冲
arbitrators
突。为什
and
么
do
呢？因
not
为
have
我们
the
没有
basic
提
information
交这
of the
个
other
我们
arbitrator.
的简历。
So he or
那
she
有
is
的时
not
候
aware
我
of
经
the
常会遇
potential
到，就是
conflicts
说，
of
哎呀，
interest
因为案
because
件做的比
arbitrators
较
do
多
not
嘛，
submit their personal
哎呀，这个仲
CVs.
裁员是谁我不知道，哎呀，这个仲裁员的名字我
In
好
my
像认
experience,
识，
in
也
many
好像不认识，
cases,
因
I
为
do
可
not
能是无
know
名的。
the other
见到了一看，哦，
arbitrator
这个人我
in
认
the
识，
tribunal.
哦，这个人我不认识，
Only
但是
when
我
we
不知
meet
道这个
each
仲裁员他
other
是做什么的
can I
啊，也就是说，
can I be
我们仲
sure
裁
that
员之
I
间
know
到
or do
底
not know this
有没有这个
arbitrator?
什么关系导
So
致
I
这个
cannot decide
可
on
能
whether
存在
there
的这个
is
利益冲突问题呢？ 那么
potential conflicts of
也是
interest.
无法来这个知晓的。那么这个呢，也是一个很大的一个问题
This
啊。
is a big
所
problem.
以呢，第7个呢，就是个别仲
The
裁员的
seventh problem,
这个信息呢，当事人滥用回避程序，我
the
刚才已
parties
经讲到了。
abuse
那么
the
第8个呢，就
challenge
是说，
process.
在实
The
践当中
eighth
啊，经常会
problem,
遇到的就是说，仲裁员呢，
in practice, we
不
encounter
提交
such
声明函，
scenarios
或
frequently.
者是
The
呢不
arbitrators
及时
fail
提
to
交声明函。
submit the
那么在
statement
开庭的
letter
时候呢，来
or fail to
提交声
submit
明
such
函，
a letter in
或者
time
说
or
他
submit
可能认
the
为存在着
statement
某一些
letter
信
just
息
before
应
the
当要
oral
披露
hearing
的。
starts,
那么他呢不在这个纸面上披露，但是呢他
or
在口头披露。
the
比方说
arbitrators
我
just
们
do the
首次
oral
开庭了，那
disclosure.
么
For
往
example,
往
in the
程序
first
上有
oral
这个询
hearing,
问仲裁员是不是
there is a
询问当
process
事人
that
是否要
the
对仲裁员
arbitrator will
提出这个
ask
回避的这个
the
申请。那么
claimant
这个时候呢，
or
这
the
个
respondents
仲裁员
whether
会披
they
露说，
want
哎，
to
我
challenge
有
the
某些
arbitrator.
信息。
And at this
那么这样
time,
的话呢，我觉得
the
呢，这个
arbitrator
也是
may
很多
make
仲裁员这么来
disclosure.
做的。但是我个人觉得呢，
This
还
is a
是存在着
frequent
很多的问题，就是说
problem we
你
encounter.
在开庭的时候提出
If
口
you
头说
make
出这些信息，
disclosure disclosure or make
往
oral
往当事
disclosure
人或者
when
说
the
代理律
oral
师
hearing
他没
has
有概
already
念，
begun, then the
那么他没有
attorney
概念以
and
后
the
呢，他
parties do
冷
not
不丁你
know
提
how
出
to
我有
deal
这种
with
情况要不
such
要回避的话，他
disclosure.
往往可能反应没有那么快的。那么反应没有那么快以后呢，他就不知道我应该不应该
And then the
有没有可
party
能
and
提
the
出回避的这个
attorneys
请求。
do not
那
know
么这样的话
whether
呢，往往当事
this
人因为
disclosure
考虑到
constitutes
不
a
愿
reasonable
意得
ground
罪这
for
个仲裁
challenge.
员，所以他就不提了。但
So
是呢，往
sometimes
往可能
the
会存在的就是说，
parties and the
因为
attorneys
他没有
just
提，那
pass
么在这个
around.
开庭结束以后，那么
But
仲裁庭往往
after
会
the
问
closing of the
双方
case,
对这个仲
the
裁程
arbiter
序有没有异
tribunal
议。
will
那么
ask
如果当事人
the
都说哎没
parties
有异议的
whether
话，
they
那么庭后可能会
have
发现，哎，
objections
这仲裁
to
员有问题啊，应该让
proceeding.
他回避啊。但是呢，
But
他丧失了这个权
after
利
the arbitral
啊，构成了弃权，或者
proceedings,
说
the
根据仲裁
parties
规则
only
没有机
react
会再提出这个可能这个回避
to
的
the
这个申请。
disclosure
所以这个
of
呢，
the
对当事人呢
arbitrators.
也是
And only at
极
that
其不公
time
正
they
的
think
啊。
that there is justifiable
那
grounds for
么
challenge, but they fail to make
第
such
9呢，就是
application
说
in
这
the
个仲
time
裁员的这个利益
specified.
冲突的这
So
个
this
检
is
索问题，
against the
那么这个
interests
我
of
就
the
不说了。就
parties.
是说
Another
我
problem
们
is with
在这
the
个国际仲裁
search
呢，
of the
往往接到这
potential
个
conflicts
某
of
一个仲
interest.
裁的案件，可能会选定或指定的时候呢，往
When
往
we
就要
receive the
进行这个检
nominations,
索，是否存在着这
we
个利
need
益
to
冲突。
make
那
such a
么我个人
search,
觉得呢，那么我
such a
们仲裁
search
员呢，
to see whether
是
there
否
is
及
potential
时
conflict
的
of
来
interest.
检索可能存在的
We
利益
need to
冲突，这
search
个呢也是
necessary
我们要
information in
要注意的
time
问题啊。
to see
那么这个
whether
呢，
there
我
is
是从仲
potential
裁
conflict
员的
of
角度
interest.
可能存在的
These
哪
are
些
the
问题，
problems
或
that
者
we
说
encounter
做得
in
不到的地方。
practice
那么这个呢
from the
是
perspective of the
这是第一个。
arbitrator.
那么第二个呢，我们客观上也有当事人的问
Next,
题。
there are problems with
那么
the
当事人存在
parties.
的哪些问题呢？
What are the problems
那
with
么
the
我个人
parties?
觉得呢，我们当事人的问题呢，不能我们不能过多的来强调，是因为你
We
代理
cannot
人的问题，
overemphasize
因
the
为你当事
problems
人的
with
问
the
题，那
parties
么造
and
成
the
了弃权
attorney.
啊，或者说等等。那么我个人觉得呢，我们无论从规则还是从程序上，我们包括我们的实
I
践的
myself
做法， 我
feel
们
that
如何
in
来平衡
practice,
双方当事人的权
we
益，
need to
如何
balance
能
the
够保护
interest
双
of
方当事
both
人的
parties
这个
and
公平的权利，
protect
以及
the
可能
legitimate
涉及到的
interest
这个利益，以
of
及
both parties
最终的一个公平公正的一个结果的问题。也就
and
是说，
their
我们规
interest,
则或者
their
法律，
right
我们不能
to
仅仅
an
保护
impartial
某一方的
arbitral
一个利益。
proceeding.
比方说，好，
We
那我后面
cannot
再说
just
啊。
protect
那么
the
当事人的
individual
仲裁申
interests and
请
rights
书
of
呢，
one specific
没
party.
有披露这个代理律
The
师的
first
信息。
problem,
当然，仲裁
the
申请
statement
书可
of the
能往往
claim
我们的
failed
仲裁
to
规则
disclose
或者说
the
法
basic
都要
information
求
of the
当事
attorney.
人来这
We
个盖章或者说签字。
arbitration law
那么这样的话
requires
呢，就
the
会可
stamp
能
and
会存在呢
signature
什么呢？
of the
就是说，
attorney and the
你机
parties.
构也好，当事人也好，
Sometimes
如果要选我，当然是通过机构。那么机构披露给我的
when
信息里
the
面呢，可能有这个申请人
arbitrator
的代
is
理律师，那
nominated,
也有可能呢是有这个被申请人的
sometimes
代理律师，有被申请人、
the basic
申请人、被申
information
请
of
人、
the
申请人
attorneys
的
of
代
the
理律师、被
claimants
申
and
请人的代理律
respondents
师。
are
那这样的话
disclosed.
呢，这个信息呢就比较完整。那么
Then we can
就
have
便
a
于仲裁员
comprehensive
呢来
information
查询是
for
否
the
存在着利益冲突
arbitrators
问题。
to see whether
但
there
是
is
呢，大部分的
potential
情况
conflict
是
of
什么呢？
interest.
是
But
说
in most
在选
cases,
的时候呢，我不知道你这个
when
申请人
we
代理律
choose
师。
the arbitrator,
当然了，可能有
when we
50%的
nominate
以
the
上的是说
arbitrator,
有申请人代理律师，因为机构会给。
the arbitrators do
但是
not
呢，
have access to the
50%以
basic
上的这
information of
个
the
呢是
attorney of the parties.
是没有这个
In
被申请人代理律师。
50% of the
那么这
cases,
样的话呢，就是说
we
对于
can
这个
have
仲裁
access
员来
to
讲，
the information of the attorneys of
无
the
法知
claimants
晓
instead of the
我到底
respondents.
有没有存
In
在的
this
可能。也就是我
scenario,
主动来查询，
the
我没有
arbitrators
办法来
cannot
查，
decide
因为信息
whether
对
there is
仲裁员
potential
来讲
conflict
信
of
息不完整，
interest
这是第一
because
个。
the information
那
is
么
not
另外
sufficient
呢，
for
是
the
什么呢？
arbitrator.
是还有很多的仲裁机构呢，这
There
个
are
在
many arbitration
在委
institutions,
任或者说
arbitration
选定仲
courts,
裁员的
when
时候
they
呢，
are
这个披
nominating
露
or
的信息
appointing
很
the
少。比方
arbitrators,
说，
they do not disclose
呃
sufficient information. For
很多有
example,
不少仲裁机构，是说，
there are
哎，
many
这个张老师，
arbitration
我们现
courts.
在有一个
For
案件，你有没有
example,
时间？首
a
先问有没
court
有时间。
approached me, asked me whether
那
I
么
have
不
a
说当事
time,
人的基本信息。
and
那么如
they
果
do
你
not
问了以
give
后呢，他在
me
口
the
头里面
basic
说，哎，当事
information
人
of
解
the parties or just reply orally the basic information of the parties and the attorneys in simple terms.
可能会是说 没有书面的。那这样的话呢，就导致
written
这个仲裁员
disclosure
很难来
of
确
the
定有没
basic
有这个利益
information
冲
of
突
the
的。所以这个
case,
呢
the
是这个
parties, and the
可能
attorneys.
也是一个机构
In
的问
these
题，可能也是
scenarios,
当事
it
人
is
的问
very
题啊，
difficult for the
对当事人的
arbitrators
信息不清。
to
那么另外
judge
呢，
whether
第二
there
个
is
问题呢，
potential
我的
conflict
实
of
践当中
interest.
感觉呢，就是说这个当事人啊，
The second
或者说
problem I
仲裁
encounter in
代理人
practice
啊，
is
他不
that
了解仲裁，
the attorneys
或
and the
者说不
parties
了解这
do
个
not
仲裁规则。
understand the
那么同时呢，
arbitration
他也不
rules
了解仲裁员回避的
and
相应的法律或者
the
是规定。
rules or the legal
或者
provisions
说这
on the
个代理律
challenge
师
of
呢，他把这个
arbitrators,
仲裁呢 当
or
成这
the
个诉讼来
attorney
做，
treats the
他认为仲
arbitration
裁跟
as
诉讼没有什么太大的
litigation,
区别。 那么他按照
not
法
aware
官的
of
这个
the
事
difference
后回避，
between
因
these
为法官的这
two
个利益冲突
mechanisms.
相对简单，但是仲
And
裁
he
员的利
treats
益
the
冲突呢比较
challenge
复杂，
of
因为仲裁员
arbitrators.
来
He
自于不
treats
同的
the
领域
potential
啊。
conflicts of interest in
所以说呢，这
arbitration,
个不
the
了解，那
conflicts
么
of
这个我个人
interest
觉得呢，也
in
是比较
litigation.
或者说非常典型的一个问题，就当事
Lack of
人代
understanding
理人
of
不
the
了解，
arbitration rules
那么
is
仲
a
裁员也不了
frequently
解的情况
encountered
下，
problems.
当事人代理人也不了解的情况下，那这个认真的对待。
Then
那么第三个问题呢，就是我刚才讲
the
的，因为你
third
仲裁员没有
problem
披露信息，那么我当事人
is
无法得到
the
你仲裁员的基本信息。那么第四个问
and
题
the
呢，或
third
者说
problem is
第四个
that
问题呢，就是说
the
我查
parties
询你仲
cannot
裁员
query
的
and
这
search the
个
basic information of the
任何的
arbitrator.
信息，并提出可能的这个回避的
And
请求
even though
啊。那
the
么我查
parties
询的这
have
个信息，
queried and searched the
以及
information of
我
the
何时
arbitrators
来提
and
出回避的请
raise
求，那么这个
or
呢
make
也是当事
application
人的
of the
不了
challenge,
解，
but they
或
do
者
not
说
know when
不
and
了解规
how
则，
to make
或者
such
说不了解法律
application
啊。这个
because the lack of
我讲的
understanding
这
of the
些
rules and
里面
laws.
呢都是有案例的，因为时间关系没有办法展
There
开。
are practical
那么第五个
cases,
呢，
but
就
as
是说
time is
当事人
limited,
呢这个
I
滥
cannot
用这个
give
回避
you
的权利，那
case
么没有证
examples.
据啊。
Another problem is the
我刚
abuse
才
of the
在这个
challenge
仲裁员的这个
procedure
内容这个部分里面
without
讲，就是说
justifiable
这个也是经常碰到的。
reasons.
但是呢，我在想这个当事人的滥用回避程序，
When the
实际上
parties
是跟
abuse the
仲
challenge
裁
procedure,
机构对仲裁员的回避的程序的决定，以及这个
this is
做法，
actually relevant with the
或者
court's
说
decisions
这
on the
个态度
challenge or the court's attitudes
是
towards
相
the
关的。
challenge.
因为你仲裁机构，比方说
For
他
the
了解你，他
arbitration
跟你秘书联系，
institution,
或者
for
说跟
example,
仲
the
裁
parties
员去信访，
contacts the secretary of the
那么你仲
court.
裁机构你比较暧昧，或者仲裁机构呢这
The
个比较犹豫，
institution and the courts do not
那么
have
一方当事人他
unambiguous
可能
attitude
就要给你
and
回辩好。
hesitates on
那么这个
making
呢也
the
是我个人觉
decision.
得呢普遍存在
In
的一
this
个，不是普
case,
遍啊，
the
也
parties
是
might
存
tend to
在的这
abuse
个
the
我
challenge
在
procedure.
在某一
This
些
is
仲
a
裁机构
problem I encountered
作为
with
替代
other
的这个首席仲裁员的时
arbitration
候， 比
courts
方说前面已经有
as a
两个首席
substitute
被
arbitrator.
回
For
避掉了，
example, in
或
a
者前面
case,
有
there are
7个首
two
席，最多的一
presiding
个是7个
arbitrators
首席被回
or
避掉了，
even seven
那么再
presiding
让我来帮
arbitrators
忙说你
are
做一下首席
challenged
仲裁员。
before
那
me,
么遇
and
到这
then
种
I
情况
am
下，往往
asked
都
to
是
be the
当事人
presiding
是恶意的
arbitrator.
这个回避，因为不可
In
能
this
这么多的
case,
首席仲裁员都存
it
在
is
着
actually the
这个
abuse
这
of
个
the
回避的这个
parties.
情形。那么这个问题呢，实际上是当事人也好，另外一个呢，也是我们仲裁机构态度是
So
否坚决的问题啊。这个呢，
the
我觉得呢也是
arbitration courts and the arbitration
跟仲
institution
裁员有关，
shall
跟
have
仲裁机构有关。
definitive attitude
那么
towards
第
the
7个
challenge
呢是说这
to
个
avoid the
当事
abuse
人或
by
代
the
理律
parties.
师
The
啊，他
seventh
往往是在
problem,
觉得这个案件不利的时候呢，他提出回避。
the
那么
parties
这个
and
时
the
候呢，他
attorneys
可能
tend to
涉及
challenge
到他不
the
了解
arbitrators when
规
they
则，
found
他也
themselves
不
in
了解法律
disadvantaged
规定，
positions.
可能构成了弃权，有这个投机取巧有侥幸的这个心理。那么这个呢，也是我在这个处理
This
这
is
个
also a
仲裁
problem
员
that
的案
I
件的时候呢，经常
encounter
碰到。
when I handle with the
往往会提
cases
出回避的时候呢，往
with
往已经没
complaints
有这个
and challenge through the
机会呢
arbitrator.
挽回了啊。那么这个呢是有侥幸心理啊。那么第7个
At
呢
that
是
time,
向机构施
actually,
压，
the
那
situation
么
can no
导致
longer be
呢
turned
刚才我讲
around.
的，导致这个
Another problem is that the parties and the attorneys pressurize on the arbitration institutions or even government agencies.
仲裁员呢，因为一看到你机构这样的一个态度，同时呢也看到这个代理人这样的一个态度呢，那么
institution do not have a definitive attitude on the challenge application, the arbitrators might withdraw on its own.
那么第8个问题呢，就是说这个
problem,
当事人呢临时更
the
换这个
parties
代理律师，
replace
或者
the
说当事人呢
attorneys
临时增加
when
代
the
理律
oral
师，
hearing
那
is
么导
about
致的
to
这个仲
start,
裁员可能存在着利益冲突的问题。
lead
那么这个
to the
问题呢，
potential conflict
怎
of
么办呢？
interest
那么
with the
是
arbitrator. How to deal with
我
such
们这
situation?
个应该要在规则层面上呢，要进行这个规定，
We
否则的话
must
我们处理的话呢也
make
没有依据。
clarifications
那
in
么
our
在国际上
arbitration
呢
rules.
是考
Otherwise,
虑
we do
这
not
个问题
have
的时
a
候呢，是
rules
考虑
to
这个
refer
仲裁
to.
庭有没有权利，
We need to
是
consider
在
whether
这
the
种情
arbitration
况下呢，
tribunal
是
has
会允许
the
这个
power
这样的一个代理律师呢，代理这个仲裁的案件，在特殊的情况下，
or whether the
那么我们国内的
arbitration
仲裁机构
institution
呢，包
has
括
the
我们海
power
南国际仲裁
to
院呢，对这个问题呢，也
hinder
有相应的规
the
定。那么
replacements
只
of the
是规定
attorney.
呢，是说你临时增加了
So,
仲裁，
for
增加或者说
the
变更的代理律师，
at short
那么
notice change
跟
your
这个
attorney,
仲裁员产生利益冲突的话，
then
你
it
首
has
先是要
conflict
进
of
这个
interest
弃权。如果
between
你要
the
提出这个利益冲突
arbitrator and the attorney, though it constitutes a waiver.
就是说你不能提出，
So
但
you
是呢，
cannot
仅仅规定这一方不
change
能提出，
at
我个人觉
notice,
得
at
呢，
short
规
notice.
则
But
层
I
面上呢
feel
还是不完善的。当然，这个
it's
是我
not
们国
a
内
good rule.
很多机构的普遍
Many
做法。
of the practice in China.
那么为什么呢？因为我提出的一个代理
The
律师，
reason is
我
that
可能
I-
是跟我肯定是不
the
提出这个回避申
lawyer,
请，对吧？
the attorney,
但是呢，我提出我
I want to
我
change
更换的这个代理律
the
师呢，
attorney.
可能是会让
It
对
may
方的代理律师提出，哎，你这个人和
that
首席仲裁员产生了这个利
the
益冲突，
opposing side
那么
may
把首席仲裁员给回避
claim,
了，
may
那这个
propose a
也是一
change,
个
a challenge.
很麻烦的一个问题，对
Then
不对？
this is a very
所以说这个呢，是我个人看来呢，我们从
sophisticated
规则层面上呢，如何来
problem.
这个完善的问题。
So how to
啊
improve our
那么这个呢是
rules?
这个代理律师啊。
So this is from the
那么还有一个
attorney's
呢，就是说这
point of view.
个
And
当事人呢对自
another
己
side
指
is
定的仲裁
that
员提出回
the
避的问题。那么
parties,
这个呢，我个人觉得呢，也
the
应当是
litigants,
从
the
法律
applicants,
上或者说
so
规则层面上呢，
laws
要
or
进
rules,
行相应的规定。
we should
那也就是说，
we
只能
should
说
clarify
你
that.
提出回避的事
So
由，应该是在你
the
选定之后，你才知
only
晓
after
的一
you
些事。那么
appointed
之前
the
呢，你不能
arbitrator,
这个提出回避，因为你自
you
己选的仲裁员，
cannot,
你对自己
you
选的仲裁员提出
choose
回避。
the
那么这个
arbitrator,
呢，
then you
以
challenge
前呢我
arbitrator.
碰到的不多，但是呢，最近呢好像
There's this kind of
通过我们
situation.
上次的讨论，
So
好像
last
不
time,
时也有发生。
sometimes
那么这个
it
发生的这个
happens.
原因，可
The
能
reason
这
of
个理由
happening
呢有很
is
多，或者
many,
说动机呢
or
也是为
motivation
了拖啊，或者
is
说
to
等等。
postpone,
当然也有可能
delay,
有仲裁员的问题，是吧？
or the
那么这个呢，我们在
arbitrator
规则层面上
problems
呢，是否要
of
进行完善的？
itself. So to
那么这
improve
个呢，是从
our
这个代理
rules,
律师和这个
this is from
当事人的
the
这个层面
perspective
上的，可
of
能这个存在的问题。
the
那么机构呢？
application
那么机构层面
parties
上
and
呢，
also the
我
attorneys
们
and also
主要是涉及
the
到我们的这个规
institute,
则，或者说我们的做法。那么第一个呢，就是规则层面
that
上
is the rules
没有
of
规定像
arbitration
这个披露义
institute.
务。那
There's
么第二
no
个呢，是规
stipulation
则层
on
面上的规定呢不明，
disclosing
或者说
obligation
不太
and
不
or
尽合理。
it's not clear
那么第
about
三
the
个呢
rules
是做
of
法。
disclosure and
那
also the
么仲
practice.
裁机构呢劝退，
Then the
我个人
compromise
觉得呢，我们国内很
that
多
to
仲裁
persuade
机
the
构啊，
arbitrator to quit.
不是个人觉得啊，是在这个研讨会的
It's
时候呢，
during our
各
seminar,
个机构呢都有
many
说，
institute
我
they said
们
that
在适当的时候呢会劝
at
退这
proper
个机构。
time we persuade the
那么这
arbitrator
个
to
呢，劝退
quit.
仲裁员当然可能是有一定的理由啊，
Yes,
或者说等等，但是呢，往往可
however
能也
it
会造
is
成
a
一个不
practice.
利的
However,
一个后果，也就是说，
it has
你只要一劝仲
consequences
裁员不
that
退呢都不好意思啊。那么
then the arbitrator will feel it's reasonable. So arbitration is rule-based, so our behavior should based on rules. So for the challenge of arbitrators, what is the rules, procedures? This is more important than simply persuade the arbitrator to quit. This is a factor that we should consider. And then the list of arbitrator. No special information about the arbitrator. And the fifth one is that the arbitrator didn't disclose the information, and also the declaration from the arbitrator that, and also secretariat of the arbitration, and the rules that if we require the arbitrator to submit the declaration that declaration of conflict of interest, then this will be submitted to the both parties or the arbitration institute in time. It's not clear. So it may lead to more or less that the practice inconsistency and not reasonable. And the next one is secretary of the arbitration. So it's problem. That is, we said that the declaration of conflict of interest, it should be handed to the arbitrator or to the both parties. However, it haven't handed to them. Or the secretary has given to the blank letter to request the arbitrator to submit, but however it haven't completed, then the proceeding is goes on. And also the next one, the decision mechanism of challenge of arbitrators. I myself think that it's also an important question that, or during our discussions, many has said that the decision making mechanism for the challenge of arbitrators, it should, I think there's an independent department that in international arbitrations, they have a committee or special panel to deal with this issue, to decide whether it should be, the challenge will be accepted. But in China, it's the practice is that the secretary will decide, and then the opinion will be handed over to the department, and the department leaders says okay or not, then it will be handed to the director of the or chairman or president of the arbitration center, and the director or chairman or director may not have time to look at it, but they approved that decision. So the secretary, management secretary, it has contact with the arbitrator. In fact, this is a preference. There's a preference or personal opinion. So it also should be looked at. And the next one is arbitrator, both parties, institutions, that the problems I have mentioned to you, reported to you, then next, let's look at the arbitration law and also the amended arbitration law, the consultation draft. So the current practice is more or less problems lies in the law that it's not clear stipulation. However, the arbitration rules, it has deficiencies. The word in black is a current law. So the composition of arbitration court should be delivered, serviced to both parties, but the revised version in red, it says that the arbitrator should sign a declaration to ensure independent, fair, and within 10 days you should claim, otherwise it's deemed as a waiver. So this is information disclosure. The challenge systems. This is no change for Article 53 that you must avoid. I think there's one slide missing. Oh, okay, 1, 2, 3, 4, 5. It should be five situations. Among those, 3 are clear, and the other is it has special relations, and the other relations that may influence fair and independent judge. This is the stipulation of arbitration law. And the arbitration for the current stipulations and before the first hearing to propose, and then who decides the challenge is accepted or not. For the first hearings, then it was already a long time, and also for after notice or knowing, but before the last hearings, it should propose the challenge. So for the before the first trial and also before the last hearings during this time, this is a stipulation. It will lead to the abuse of these rights, to intentionally delay the process. And the revised version says that for the arbitrators you appointed, it should submit the reasons after you appointed the arbitrator. And for the challenge, as the procedures can go so, it's improving. The arbitration law has considered these questions. And next, I want to report to you the model law, the UN Trade Law Council, International Commercial Arbitration Model Law. I want to report to you. We know that UNICEF model law, international arbitration, how to understand the international arbitration law. So we can understand the model law so that to understand international arbitration, its common practice, different countries. Some of them are not signatories of this model law, but however, more and more country becomes a signing party of the model law. So an easy way to understand that, as well as the topic we discussed for the avoidance of, for the challenge of arbitrators. So the unilateral model law, we have 85 countries adopted and 118 jurisdictions adopted. For example, China mainland, not a signing party, but however, Hong Kong and Macau of China are the jurisdictions of the model law, and also American, UK, Australia, Canada, they are similar. Some of the countries, the country is a signating country, but some of the country, but many of their states or jurisdictions applies or adopted the model law. So to use, so the model law says that it's more scientific, so that we, the
I suggest that we can't consult the model law when we revise the arbitration law. And for the arbitration institutions with high caseload involving international parties, we can adopt the model law in our arbitration rules. Article 12 and Article 13 deal with this issue. Article 12 provides that the arbitrators, when nominated, shall make disclosures. So when the arbitrator is approached by the institutions, shall make disclosure, shall disclose the situations which might give reasonable doubts as to his or her impartiality. And it also requires that during the whole proceedings and after the appointments, the arbitrator shall make disclosure without any delay. That is to say, you need to make disclosures during across the whole arbitral proceeding. So 12 also requires that there must be justifiable grounds for the challenge. After the appointment, the parties may challenge the arbitrators appointed by the parties on the grounds, on the issues that the parties become aware of after the appointment. So there is a special provisions as to the challenge to the arbitrator appointed by the party himself. Article 13 deals with the procedure of the challenge. First, we respect the autonomy of the parties' will. If the parties have agreed on such a procedure, then we comply with the procedure. Failing such agreements, within 15 days after the establishment of the tribunal, the parties shall make application of the challenge. That is to say, the parties need to search relevant information within 15 days after the establishment of the tribunal and make written statements to the tribunal. This relies on the premise that the arbitrator has made disclosure. Unless the parties agree or the arbitrator withdraws, the tribunal shall make decisions on the challenge. Please be reminded that it involves ad hoc arbitration and institutional arbitration. So the decision making is with the institution.
那么如果是机构的话呢，可能就是根据机构规则，是由机构
If
做出这个是否
it
回避
is
的
an
这
ad
个决
hoc
定。那么这个
arbitration,
呢
the
情况是不一
tribunal
样的。
shall make decisions.
好，
If it is an institutional arbitration, then
那
the
么
institution shall make
关于这
decisions
个决
on
定，
the
它
challenge.
是可以提出这个按照提出这个法院，那么进行这个诉讼的。那么这个呢，我们要特
The
别
parties
注
may
意啊。
submit
那
the
么也就是
challenge
说
to the court
如果是最终按照你国家的这个仲裁法，如果是由
based
机构
in
最终做
accordance
出决
with
定，
arbitration
或者
law.
说是由法院
If
最终
the
做出决定的
arbitral
时候，
tribunal
法
make
院
the
就可
final
以
decision
到
or
法
the
院去诉
courts
讼
make the final
啊。
decision, then the
但是呢，
parties
这个
can
机构呢，你必须要做出一个决定，
submit
啊
the
你不能不做
case
出决定啊，
in
以及
front
给
of
出
the
理由。
courts. But the
那么这个呢是比
institution
照这个
shall
示范
make
法，也就是说示范
a
法
decision.
所规定的就是说你应当信息披露。第二个呢，这个
Model law
披露
requires
披露，
first the disclosure of
当事人
information.
你提出这
Second,
个回避
the
申请的话呢，必
parties
须要有理
make
由，以
application
及要有日
with
限。
justifiable
第
grounds
三个呢，就
within
是
a
说做出
specified
决定
time
的机
period.
构以及是
Third,
否可以上诉的问题啊。那么
the
这个呢
decision
是
is
这
made
个
by
国
the
际仲裁我们
institution
示
or the
范法
tribunal
这个规
and
定，那
whether
么
the
我们呢
decision
是
is
可以进
appealable.
行参考啊。
We
那么
can't
但是在国际仲裁呢，
consult
很
the
重要的一
ancestral
个
model
关于
law
仲裁
when we
员的这个
revise
利益
our
冲突的一个
arbitration
指
law.
引。那么这个
There is
指
a
引呢，
guideline
我们做国际仲裁的话呢，
on
我们必须要了
conflict of
解。当
interest
然了，这
we
个呢，
must
在
be
我们
familiar
国内呢，
with.
也逐步的被
This guideline
被这个很多机构
has
以及这
been
个仲裁员所考虑。也就是说，
has
我
been
们
more
这
and more
个仲裁员
considered
的这
by
个
domestic
利益冲突
institutions and
问题、信
arbitrators
息披露
when
问题，
handling the
我们要
potential
不要
conflicts
参
of
照这
interest
个 IBA
and
的国际
disclosure.
仲裁利益
That
冲突
is
指引的问
the
题？那么这个
IBA
呢，是我们
guidelines.
国内呢争议比较大的，或者说
But
我们
should we consider
仲裁
or
员也比较
apply
困惑的。
IBI
那么我个
guidelines
人觉得
on
呢，是可
conflicts
以
of
作为一个
interest?
参考，
There is a
因为这个是
controversy
这
and
个
doubt.
它也仅仅是一个
In my
指引，
view, we
也并不
can
是一个这个法
refer
规，或者
to
说它
these
是一个语言法
guidelines.
啊。
Anyway,
那么
it is a
关于
soft
它的
law
适用问题呢，那么在之前的这个讨论的时候呢，
as to its
有很多人有
application.
观点说直接把它引用
Some
就行了啊。那么大家也有
some
不同的这个
experts
意见啊。
think
那么
that
对这
we
个指引的
can
这个适用问题呢，
invoke
实际上也
the
存在着一
provisions
个
in
误
the
解。那
guidelines.
么根据我
But
对
there
这
are
个
many
IBA 的这个国际仲裁
misunderstandings as to
这
the
个利益冲
application
突
of
指
the
引的
IBA
这个研究呢，
guidelines.
我觉得呢，它
Based
的这
on
个
my
适用呢，
research,
是有几种情况下呢，
I
是我
think
们
there are
必须要
several
考虑的。也
scenarios
就是说，你
where
不
we
考虑的话呢，
must
就可能
consider
会有问
IBI
题。
guidelines. Otherwise,
第一
there
个呢，
may
就
be
是当事
problems.
人明确约
First,
定，
the parties
也就是说，
have
我们在这个仲
agreed
裁协议里
upon
面约定了，
the
说
application
仲裁员
of
的利益冲
IBA
突问题，我们
guidelines.
要
That
依
is to
据的
say,
是这
the
个
parties
IBA 的
have
这个利益冲突指
provided
引。
that the
好，所以
IBA
说当事人有
guidelines
约定，我
shall
们必
be
须要 信
applied
息约定。
when there is
第二个
potential
呢，是
conflict of
说
interest in the
某一
contract.
个
The second
仲裁，我们
scenario
这个
is
仲
that
裁在某一个仲裁机构进行仲裁。那么
if
我们这个
we
某一个
submit
仲裁
the
机构呢，
arbitration to an
它的仲裁
arbitration
规则
court,
里面呢，
and
它
in the arbitration
把这
rule
个
of that
利益
court,
冲突的这个指引呢，
these
它引用
guidelines
了。
is
比
adopted.
方说，这
For
个好像是
example,
2021年还是
in
2020年， 那么澳大利亚国
2010,
际商
in
事仲
Australia
裁中心
International
呢，
Commercial
它的这个新的
Arbitration
规则
Center,
呢，它
in
把这
his
个
latest
IBA
edition
的国际
of
仲裁利益冲
arbitration
突指引
rules,
呢，把它
IBA
引用到它这个规
guidelines
则里
is
面。也就是说，
adopted in the
它在
latest
仲裁员的利
edition
益冲
of
突
its
信息披露这个
arbitration
地方呢，
rules
他说要
on
参照
disclosure
这个
and
IBA 的这个指引。那么这
the
个呢，
handling
就
of the
为我
conflicts of
们对我
interest.
们仲裁员有约束啊，这个呢
So
也
this
是
is
可
binding
以这
on the
个根据规
arbitrators.
则来进行适用。那么第三个呢是
The
说，
third scenario
这
where
也
we
是
should
我在国际仲裁
consider
经
and
常遇到的
apply
问题，
the
就是说，
IBA
或者
guidelines
说经常使用的办法，
is that
就是说我仲裁庭主庭以后，
after
那么
the
仲裁
tribunal
庭
is
的这个
established,
程序令，也就通常在
the
第一
tribunal
号程序
issued
令
a
里面，
procedure order. The
把
first
这
procedure
个
order
当事人如果对仲裁员可能
provides
存在的
that
利益冲突和
if
信息
there
披
is a
露利益冲
potential
突问
conflict
题，
of
要
interest
提出
and
这
if there
个
is issues
回
with
避的
the
话呢，
disclosure,
那么
and
我
if the
们这个比
parties
较
want
谨
to
慎的这
challenge
个
the arbitrators,
呢，往往
the
会把
arbitral
这个
tribunal will
关于仲裁员的信息披露和利益冲突这个问题呢， 也把它列在这个
Arbitral
第1号程序
tribunal
令里面。
will
也就是
list
说，关于
these
仲裁员
issues
的信息披
in
露
number
和
1
这个
procedural order.
利益冲突问题。那么如果有争议的话呢，是按照这个 IBA 国际仲裁
And
这个利益
sometimes
冲
in
突
the
指引
procedural order, the
作为
tribunal
参考
will
或
clearly
者说
provide
执行。
that
那这样子的
we
话呢，
can
那么
refer
对于我们
to
仲裁员
or
来讲呢，
apply
就具有
IBA
一定的这个约
guidelines
束力。
on the
所以说
disclosure
我们
and
只有在
conflict
这
of
3种情
interest.
况下，否则的话
So
呢，
only
这
in these
个
three
国
scenarios
外
we
很
can
多的判令
consider or even
对于
apply
IBA 的这个
IBA
利益冲突的指引呢，
guidelines. There are many
往往
foreign
都是
cases
说
on the
除非是
application
必
of
须要适
IBA
用，否则
guidelines,
的话
and
呢，
their decision
仅仅作为
instead,
一个参考，并不是
IBA
说当然的
guidelines is
法院
not
根据这个利益冲突
mandatory
指
for
引
us to
来确定你
apply.
仲裁员跟当事
It
人之
can
间是
be
否存在
a
着这样的一个
material
关
for
系，
us
是
to
否违
refer
反了这个
to when
IBA
we
的这个利益冲突
consider
指引，
relevant
那么来
issues.
考虑你这个仲裁庭是否应当回避没回避导致的仲裁庭主庭存
When
在的程
we
序问
make
题，而
decisions
不
on
予
the
执行，或者
challenge,
说撤销仲裁裁决。
the
所以这个呢是
tribunal
也是
can
非常谨慎
refer
的
to
也
IBA
是要看
guidelines
具体的案
in
情。
decision
另外呢，我
making.
们也不要动辄提出
And
说
for
IBA 的这个利
arbitrators,
益冲突指引就当然适用，所以这个呢是存在着误解。
we do
但
not
是呢，我们
take
仲裁员呢，
the
我们要
application of
做这个
IBA
仲裁，我们
guidelines
要
as a
有志于
grounds.
成为一个仲裁员，或者
For
说国际仲裁员，
arbitrators,
那么我们就要了解这里面所规定的内容，
we
对
must be
我们来讲是一个
familiarized
参考，
with
是一个非常有
the
价值的一个
rules
参考。
in the IBA
那么在
guidelines.
我国适用的可能性，我刚才讲了。那么另外呢，就是说我们是否要根据这个
I
指
have
引呢，要
just
由我们
explained,
这个国
do
家
we need
根
to
据我们的
apply
国情，
IBA
或
guidelines
者
in
说结
China?
合国际，
That,
那么有一个我们认为普遍适用的
in
可能
my
指引，
view,
那么便于我们仲裁员来
maybe
考
we
虑，
need
便于我们当事人来考虑，
maybe
便
we
于我
need
们仲裁机
to
构来
come up
考虑
with
这
a
个问题如何
guidelines
来进
that
行处理
can
的
be
问题。那
widely
么这样的话呢，就可以
accepted,
解决这方面
which
存在的问题。
conforms
那么 IBA 的
with
这个指引呢，我
specific
就不
conditions
多
in
说。
China.
那么这个指引里面呢，它规定了有那个
In the
红绿灯
IBA
嘛。
guidelines,
那
there
么
is
红色的
white
红色的
lights
分
and
两类，
green lights.
第一个
White
呢是不
lights,
可
there
实
are
施，
two
也就是说，
categories.
第
First,
一类你是绝对是不能做
unwaverable
的，
list. That is
绝
to
对
say,
是
these
不能做
are
仲裁员
the
的啊，
institute
不是披露
the
不披露的问题。那么
list
第二
the
类呢是可弃
situations
权的。
where
那么它的
you
可弃权
cannot
的含义是，并不是
challenge.
说我当事人没有提
And
出
another list
而弃权，
is
而是说只有当
waverable
事
red
人明确
list.
同意的
Only
情况
with
下，
the consent of the
那么你
parties
这种情况下才可以
you
做
can
继续做仲裁员。 也
continue
就
to
是
be
说，
the
你存在着
arbitrator.
可弃权的红色
That is
清
to
单的这
say,
个事
you
由的话，
have the
不是说我
issues
披露了，
in the
当事人没
waverable
有
red
说
list.
我就可以做，不是，要当事人明确同意的情况下，
You
你才
made
可以
the
做。因为
disclosure only
这些
with
事项呢，
the
都认为是比较严重的事项，
express
但是
consent
呢，并不
of
是
the
说
parties. You can continue
不
to
可
be the
弃权的
arbitrator.
这个里面的这个事
If
项那
there
么
is
严
a
重，但是呢，
situation
也足
in
以严重
the
到
waverable
这
red
种情
list,
况必须要双
that
方当
means
事人
this
同意，
event is
或
serious
者说有一
enough
方同意，往往是一
to
方来同意
have
说，
the express
认为这
consent
个要
of the
这个利
party.
益冲突要你回避，对吧？那么这个时候呢，要当事人明确同意才行。他不明确同意，就表示
Without
不同意，
expressed
而
consent,
不能适用这个弃
the
权的
lack
这
of
个
express
简单的
consent
弃
of
权
the
的方法。
parties is deemed as
啊
no
那
consent.
么橙色的清单呢，是说
Another list
需
is
要披露，
orange list.
就更
It
加的
means
这
that
个相对来讲
if
重
there
要
is
性呢
following
更弱了。但是呢，这些信息
situations,
呢，可能
the
足以导致你
arbitrators
这个
need
仲
to
裁员
make
存在的这个利益冲
disclosure.
突。那么这个时候呢，是需要当事人你要及时提出的。如果说
You
这个仲
and
裁
the
员披露了这个
parties
事项，
need to
那么
make
你觉得这是
objections
在
in
橙色清
time.
单里面，那么这个时候呢，你要提出说我要求他回避。那么这个时候呢，这个仲裁机构呢，再
And
来
in
做
these
出
events,
这个
the
决定
arbitral
是否
tribunal
回
will
避的
make
问题。
the
那么也就是
decision
橙色
on
的
the
是
challenge.
可以往
That
红
is
的
to
靠，也可以
say,
往绿的靠。那么根据具体的这个事由，
the
但是你必
events
须要披
in
露。
the orange
那么你
list
如果不披露的话
may
呢，
become the
这
grounds
个
for
IBA 的
challenge
指引并
or
没有
may
说
not.
这
That
个一定
depends
是
on
说
the
采
specific
取这个不
case.
利不利推定。但是呢，我们国内有一些仲裁机构呢，对于
We do not
说
build
我规则要
adverse
求你必须披
forums for situations in the orange list. It is different from our own
那么这个呢是橙色的清单。绿色
provisions.
清单呢是原则
There is
上你可
another
以不
list
披露，
that is
但是
green
呢你
list.
披露了以后呢
If
也没
there
有
is
问题。
a situation
那么这个
in
呢
the
是
green
这个
list,
4类的这
the
个清单。
arbitrator is
那么
not
我们作为仲裁
obligated
员的
to
话呢，
make
我们
disclosure.
了解的话呢，对于我们来讲呢是有所
I
帮助的，
think
有
this
所帮助的，
list
或者
can
说
help
我们大概
us
有一个概念。
in our
当然我们
practice,
并不一定要严格按照这个来做，
but
但
we
是呢
may
我
not
们有一个
strictly follow the
指导性的
guidelines,
一个
but we can be
一个参考。
familiarized
那么
with
这个
the
呢是
list,
我介绍
so
的
we
这
can
个指引。
refer to these
那么接
provisions
下来呢，我介绍一
when
下
we are
就是
dealing with
说这
our
个
own
台湾的
cases.
做法。
Next, I would like
那
to
么台
introduce
湾
the
的
practice
这个
in
当时李红店
Taiwan.
理事长他来介绍的时候呢，他呢说呢是说，我有要
In
求，我
Taiwan,
的要求你有声明函，
they
仲裁员
required
你要
statements
你要
letter
有这个
of
声
the
明函。
arbitrators.
那么他在这个网站上的这个要求。那么
On
第
the
三个呢，
website,
第二
we
个呢是
can
这个声明书。
see the requirements on the website
仲裁员的这个声明书。
requiring the arbitrators to
这
submit
个第
the
四个呢
statements
是仲裁
letter.
员评判利益冲突或揭露事项检查表。
And
那么
there is a
台
checklist
湾地
for
区
the
的一个做法
arbitrator
就是
to
说，
make
我列出27项，
disclosure
那
and
主要
to
也是
judge
这个
on
IBA
potential
利益
conflicts
冲
of
突里面
interest.
他认为比较重要的内容。你要打勾到底有还是没有？
There is a
那你要打
checklist
勾了，打叉，
for the
完了以后呢，就
arbitrators
作
to
为一
click.
个这
If
个
you
跟
click
声明函在
a
一起，
specific
是要
event,
给
then
这
you
个当事
need
人，
to
或
attach
者说
the
给
checklist
这个仲裁庭。
with the
那么这样
statement
的话呢，
letter
就
to
很容易
submit
哦，你
the statement
你原来
letter
是说是没有，那
to
我一
the
查你
tribunal
有，
and the
那么这个就
parties.
是你仲裁员的问题了，是不是？你
If
披
you
露信
do
息
not
存在这个问
click
题啊。
on the checklist, but is found to
那么也
have
便于这个我们仲裁
the
员呢去知
situations
道，哦，
listed
我
in
应
the
该去做哪
checklist,
些事情。
then
所以
that
这个呢，
may
我觉
give
得呢非常
rise
有这
to
个参考
doubt.
价值。那么我们国内的机构呢，是不
I
是
think
也可以
Taiwan's
来参考？
practice
当然，
can
现
be
在我们国内很多
consulted
机构呢，
as a
已经逐
reference.
步在完善自己的规则，完善自己的仲裁员的守则，以及
So
完
that
善
to
仲
improve
裁员
our
信息披
rules,
露
the
和利
menus
益
for the
冲突回避的这个做
arbitrators,
法。
and
这
also
个
the
呢是这
practice
2
for
年
the conflict
确
of
实也
interest
是
in the past
这
few
方面
years.
呢
We
有
have
很
done a
大的
lot
一
of
个改
work
进。
and improvement.
那么另外呢，我再给大家介
And
绍一
I'd
下我
like to
在香港
introduce
的
to
这
you
个，
that
或者
in
是
Hong
在香
Kong,
港、新加坡、
Hong Kong,
ICC 啊，
Singapore,
我在做仲裁
ICC,
员或者是
as
仲裁
an
员的利益冲
arbitrator
突
for
这个
them,
情况。那么这2个案子
some
呢，
of the
都是我做在
experience.
香
So
港
these are
做
the
仲裁员的时
cases
候呢，
in
我
Hong
所
Kong International
经历的
Arbitration
一个感受。
Court.
比方说，
For
这
example,
个中文的英文的内容
the
是2个不同的案件，
Chinese
但是呢，内容
English
是一样的，
version
只是
are
一
two
个是英
separate
文的案件，一个
cases,
是中文的案件。
but one
那
is
么这2个不同的案件时间也
conducted
不
in
一样。
Chinese and one is conducted in English. So
那么这个仲裁的这个
for
秘书，因为在
arbitration,
在
Secretary
境
of
外或者说
Arbitration
在我们大陆之外的这
in
边的时候
outside
呢，
mainland China,
不把这个仲裁机构的
we
这
were
个管理人员呢，把它作
not
为秘书，因为仲裁秘书呢，
the
特许
secretary
在
of
境
the
外或者说大
arbitration
陆之外呢，我们一般用
outside
特许
mainland
仲裁秘
China.
书是指
We
仲
refer
裁
to
庭的秘书，
the
而不是
court
仲
of
裁
arbitration,
机
not
构
the
的这个秘书，
not
这个呢
the
跟我们国内
arbitration institute.
有所区
So
别。
there's a
那么
difference.
他的这个
The
案件管理人员呢， 那发了一
case
个电邮
management staff
说，哎，
send
我
me
要
an
求你
email
提供什么信
that
息呢？第
to
一个，
submit and
你这个中英
the
文的独立
information
声明函，
that the
对吧？
bilingual
第二个呢，你的小时费，当然
declaration
这个是按照适用这个小时来收
of
费
acceptance
啊。
and statement
那么
of
第三个呢是说
availability,
你的中
impartiality,
英
and
文的简
independence,
历。
and your
所以
proposed
说我刚才
hourly
在给
rate
大
and
家
a
介绍
copy
的时
of
候，
your
我是
latest
说，这个
curriculum
仲裁员
vitae.
选你做
So
仲裁员的时候呢，你不提供
if
简历，
you have been
那
selected,
么机
you
构也
don't
没问你要，
submit
当时你仲裁
CV,
员也没有提交，那么当事人
they
不知
don't
道你的
submit,
基本信息，
they don't
那
know
么怎么来查询
how
你的信
to
息呢？因为要查你的信息
retrieve
有的时候很难的，
your
困难的，
information, sometimes
所以让我
difficult.
们当事
So
人是非常的不便利啊，所
it's
以这个就是
inconvenience
这
for
个香
the
港的这个做法。好，
parties. There's a
这个
practice in Hong
是
Kong
包括这个新加坡也好
and
，ICC 也好，
including
都是很多。好，
Singapore
接
and
下来，
ICC,
那么我在这个英文的这个案
and
件里面
also
呢，
in this
是我披
English
露了一个信息
language
以后，那
case,
么这
when I
个
disclose
香
my
港国际仲裁
information,
中心
the
的这
Hong
个
Kong International
这个
Arbitration
案件管理
the case management staff sent me an email that they have researched on me and find some of the information. It's not clear. or don't understand, and they require me to provide or clarify further information for clarification. For example, legal in-house counsel has worked in your law firm, or previous your colleague, previous lawyer working in your law firm has represented this company. However, they don't know the relations between the lawyer and you. So it's reflected in these details that, according to law, to find this information, but not know exactly the time and the relations. You participated in that in the previous case, they don't know, so they require clarification. After clarification, you declare whether you should be challenged and give you some time. Another email not listed in this. So according to a required time, you reply. This is an international institution, their practice, formal requirement based on facts. You should make clarifications and whether you should be challenged. The challenge will be accepted and to submit your respondents. So compared with the institute in China, different practice, and they so just refer to you and not a clear subsequent procedures. So many problems may emerge. For example, let me to withdraw, but I'm not going to quit, or no written document. So one arbitration institute, the reasons argument is without foundation, without evidence. So I don't know the following procedure. For example, that say we just worked in the same arbitration institute. I think this is not a solid foundation for challenge. And also, what next step I should do? So I'm waiting for their notice. However, I forget that 2 months, 2 months passed. Then how to proceed the case? Then no reason. However, are we going to continue the proceedings? So in one institute, they said that you will not quit, you will not withdraw after 1 or 2 months. And then the secretary don't give me any directions what to do next. And when I was waiting, so we will continue. These are the situations I have met. And I have also met that after learn from this, in another case, for challenge me, then almost 20 years ago, something related to me. And then I received this information. I told the secretary that there's no relation to me, happened 20 years ago. I even didn't know that about the acquisition, merging of company. I have left the company before that time. 2 days after, the hearings will be conducted. I submit this challenge. And this case has been postponed by COVID-19. This is obvious intention. And I have booked an air ticket. Can you make a decision? And I didn't get a reply. And after I canceled my flight, almost 3 months, I'm asking, keep asking. And I like to submit some material, for example, about I have left that company 20 years ago. I have submitted this evidence, and 2 months passed already. They haven't made a decision. So this is also the practice I have met, situations I have met. This will lead to the consequences of that. For example, I'm not going to do this, hearing this case. But if I'm going to here, I quit voluntarily, then it's not fair for those party who has chosen me. Or can they choose the other suitable arbitrators? Many questions to ask. Or if another arbitrator comes, then the same reason, abuse of these challenge rights. So, okay, so but there's no final decision until today. But they replied me, okay, we will do it soon, and the decision will be made soon. So I think this is important for the institute to have a clear rules. Okay, so next I'd like to report to you, because we are Hainan International Arbitration Court. The rules of Hainan, it's good. The arbitrators should take notice. The latest arbitration rules, the first one is after being appointed or chosen, we should sign the Declaration of Independence, Fairness, and also this declaration will be sent to both parties. So the secretary will give to the parties. And the second one is, if we know there may be situations that may lead to the suspicion of fairness, independence, then we should disclose in written form or in hearing that this is during the arbitration process. Our obligation to disclose. And the third one is, once after the disclosure, the parties should, within 5 days, whether they propose a challenge, to give a written document. And the fifth one is that if it's not proposed, submitted in time, it constitutes something as a waiver. And then you will not propose in the future. And the Article 27, it says that for the following situations, circumstances, it must quit, withdraw. For example, taking gifts, etc. This will quit, avoid, withdraw. And Hainan International Arbitration Court, the following articles, it's improvement for the arbitration law, that the parties have the rights to propose a challenge. And the third one is that and to propose the challenge, you need to submit evidence and elaborate in written form. And the fourth one is
这个我看看啊，这个第3条是这个披露信息的。
disclosure, information
就披
disclosure.
露信息之外，你必须5天之内，对吧？
Within 5 days
这个申请构成弃权。那么对于仲裁员的
to
回避申请，
propose
那么你应当
and
是在
also
首次开庭前提出。
before the first
那
trial
么在首次开庭后
for
知道的
the
话呢，
challenge of
和在
arbitrator.
最后
After
一
you
次
know
开
the
庭终
reasons
结前提
of
出。
for the challenge of arbitrators, it
那
should
么
be
这个呢
before
是
the
规
last
定了
hearings.
首次开庭前提出和最终的
It is
这个
before
终
the
结前
first
提出。
hearing and before the last hearing.
那么另外呢，不再开
And
庭，
also,
或者说书
if
面审理的案
it's
件，
a
应当
written
知晓以后
review,
这个5日内提出。 那么
should
这个呢也是
submit
规
within
定
5 days
提
after
出
knowing
这个仲裁员回避的这
this
个
is
时
the
间。
time limit.
另外呢，也规定了秘
And
书
also
应
they
当及时
should
向这个
in
回避的
time
申请呢
to
发
send
给其他
the
当事人和仲裁
notice
庭的成
to
员。
the
那么
other
这个规定
parties
呢都是
and
非
the
常
other
的具体。
members
那么
of
在
the
我们国内的仲
arbitration
裁规则里
court.
面呢，也是比较
This is
比较完善的，或者说最完
detailed
善的这个仲裁规则之一，
one
也是
of
非
the
常领
most
先的一个
comprehensive
这个规定。
rules.
那么这个呢都是有
This is
明确的规则的要求。
clear rules.
那么第6点呢是说，
And
这个当事
the
人同意
sixth
或者说主动退出
point
这个
that
不构成这个回避。那么这个
the
呢都大部分的机构规则里面也都有。
voluntary quit,
那么
voluntary
第7点呢是
withdrawal,
说，这
and
个
the
回避的决
seventh
定呢是最终由理事
ones
长来
to
决
be
定。
decided by
这个
the
最高决定
consular
最高这
Paragraph
or
个
chairman.
7
这个行
provides
政这
that
个负责人
the
和我们
decision
理事
of
长
the
这个决定
challenge
制
is
啊。
made by
那
the
么第
chairman
8点
of
呢是
the
说，
court. Paragraph 8
就是
provides that
说你如果知晓的话呢，
if you are
就视为
aware,
当事人就是放弃权利的问题啊。那么另外呢，可
paragraph
能
8
涉及
involves
到的
the
这个
waiver
这
of
个费
the
用的这个问
parties
题。
and the
那么你知
arbitration
道以
fees.
后呢，你应当要及
When
时
you
地提
become
出回避，否则
aware,
的话
you
构成弃
need to
权。
make
另外一个呢，你
applications
如果
in
说是
time,
这个滥
otherwise
用权利的话呢，
you
可能
waiver
会
your rights.
这
And
个
if you
承担相应的这
abuse
个费用。
the rights to
那么第
challenge,
9 点
then
呢
you
是
may
关于
be
秘书
asked
鉴
to
定人员
make
等等，按
additional
照这个仲裁
payments.
员的回避规定。
And
那么这个呢
paragraph
规定的
9
呢非常的
asks
具
the
体，值得我们
secretary
仲裁员
and
呢
other
特别的
relevant
注意
persons
啊。
to
所以呢，这个
refer.
接下来
Paragraph
呢，就
9
是
refers
我
to the challenge of
再有2分
other
钟时间我就结束
persons
了，就是说
involved,
这个我们
including
仲裁员的信息披
the
露啊，我们应当
secretary.
及时，我们要全过程的这个披露。那么我们的这个披
For
露
the
呢，要根据仲裁
disclosure
法
of the
主张规则。
arbitrator, the
那
arbitrator
么
shall
第二个呢，我
make
们要参照这
full
个 IBA 的这个指引。
disclosure
第3个呢，我们
across
是不
the
是
whole
考虑应当
arbitral
由我们
proceeding,
国家
and we
统
need to
一适用的一
abide
个
by
指
the
引。
arbitration
那
law,
么第4个呢，就
and
是说
we
我们要
can
及时
refer
披露
to
这
the
个仲裁员的
IBA
基本信息，
guidelines.
无论是仲裁员披露还是仲裁机构披露啊。那么第5
The
个呢，是我们
disclosure
仲
can
裁
be
员呢
made
要
by the
及时地利用
arbitrator
公众
or
的
the
检索，并
institution,
且及
and
时地
we
提
need
交
to
这个声明文
search the
啊。同
potential
时呢，
conflicts
要
of
把这个
interest
声明文
involving
呢
the
要
arbitrator
给
and
这个
submit
当事人
the statement
和这
letter
个仲裁
to
庭。
the parties
那
and
么
the
另外呢，就
tribunal.
是说我们关于仲裁员回避的程序以
As
及
to
相应的
the
这个决定。
challenge procedure and decision
那么我们
making,
回避呢，应当请求
the
呢，应当
challenge
及时地送达
request
当事人
shall be
和
delivered to
仲
the
裁庭的所有的
parties
仲裁员，
and all of the
那么让大家知
arbitrators
晓，
in the
那么
tribunal
大家来做出一个
so
判断。
that we
因为
can make
有可能
decision.
一方提出，另外一方
Because
认为也应该
it
要
may
回避，那
happen
么这样的话
that
呢，就
one parties
双方
make
达成一致嘛，就
application,
回避
the
了，
other
对吧？
parties
我们不能
agrees
想当
to
然
the
的，就是说
application.
一方提出
Both
回避，
parties
另外一
reach
方不同意回避
agreements.
啊，这个是第
We cannot
4
take
就
for
是决定了
granted
这个第
that
一个问题。
maybe the other
那么第二个
party
问
do
题呢，
not
就是说
agree with
要
the
给予这
application.
个被提
Another
出回避的仲裁
problem
员的一
is,
个答
another
辩的
issue
一个
is
义务
that
啊，这
we
是一个
have the
义务，
obligation
书
to
面答辩，
give the
你不能说
opportunity
是
to
口
the
头的，
arbitrator to
或者
make
说
a written
不回答，
pleading.
导致这个程序的这
The
个拖沓
arbitrators
啊。第3个呢，就是
shall
说我
make
们的决策
written
的部门。
pleading,
那么
and
刚才我已经
he
讲
or
了，我
she
们
cannot
决
refuse
策的这个部
to
门，
reply
回避
to
的
the
决定委
challenge
员会
application.
应当要有一个
And
独
the
立的一
decision
个委员
making
会，或者说
is
独立的委员
with
会，这个
an
领导下呢，
independent
就个案
committee
进行的一个专家的一
or an expert designated by that dependence committee.
做出一个最终的一个决定。那么第4
or
点呢，就是
the
说这个
chairman
决定
of
呢，应当
the
要给
courts
到
can make
当
the
事人
decision on the
和仲裁
challenge,
庭，
and the
并且呢说
decision
明理由。
must be delivered to the
那么第5 点
parties
呢，就
and
是说
the tribunal
是否
with
可以参照
reasons
国际
explained.
仲裁某一些仲裁机构，比方说这个伦敦国际仲裁中心，
We may
比方说
refer
斯德
to
哥
the
尔摩国际仲裁院，
arbitration
那么
rules
他
of
们有的是
other
在
international
伦敦是
institutions,
在
for
这
example,
个
London
2010
International
年
Arbitration
2010
Institution.
年就
In
做出决定，
2010,
就是说这
London
个他
Arbitration
的这个
Center
机
have
构做
made
出
a
的回避的
decision
决定
that
呢，
the challenge
经过保密处理以后呢，就可以这个
decision
公开。
can be
那么这个
open.
斯德哥尔摩国际仲裁院呢，是在17年还是18年，
Stockholm
那么
Arbitration
也紧
Center
跟，
in
那么也做
2017
出这个理
follows
事
the
会的一个决
practice
定。
of
那么
London.
目前呢，这2个机构呢是明确的把仲裁员的这个回避的这个问题的这个决定呢，
Now they
是
clearly
脱密以后呢进行公开。因为
provide
这个
that
的
the
这
decision
个
of the
也非常的
challenge
重要，
can
因为
be
这
made
个便于
public
让仲
and
裁员知道我
open
哪些真的
after
是应该
they
要
have
回避，
dealt
或者
with
说
the
当事人知
issues
道我
of
哪些应该提
confidentiality,
出这个回避，否则的话大
so
家都不知道
that
怎么
the
来做
parties
那么这个呢
can
是具有一定
understand
的这个
in
案
what
例的一个
situations
指导
they
意义
can make
那么这个呢
application of
是
challenge.
关于这个程序的问题。那么我们国内的仲裁机构呢也可以进行借
In
鉴，
domestic
那么增
institutions,
加我们仲
we
裁
can
员
learn from
信
this
息披露
practice
和仲裁员
to
回避
improve the rules
以
on
及这个决
disclosure
策制度的这
and
个
the
透
challenge
明度呢，
procedure and the
也是
decision
便
making,
于
in
我们
particular
仲
the
裁的这
transparency
个共
of
同
the
体各
decision
方
making
来
process,
了解，以及
so
来
that
对我们
all
这个仲裁的
parties
公信力
involved
呢，
in arbitration can
能
have
能
better
够有一定
understanding
的
of
这个
our
信心
rules
啊，
and
能够
can further
保
improve
证或者说维护
people's
双方
trust
当事
in
人的
arbitration
这个合法的这
and
个权益。当
maintain
然了，
the
也维
legitimate
护仲
interest
裁
and
员
rights
的
of the
合法的
parties
权益。因
and
为仲裁员
protect the
办了
interest
7年了，
of
这个
the
办了3、4
arbitrator.
年的案件，开了7、8次庭
For
了，
an arbitrator,
对吧？莫名其妙
he
被要求
may
回避了，
have tried the
那
case
么1
for
分钱
several
拿不出，
years, and then
然后
he
呢
is
换了一个仲
asked
裁
to
庭，换了一个仲裁庭
withdraw
以后呢，
without
把
any
开了
payment
1次庭，
stand
把这个案
with
子
a
给审了，
different
最终裁决做
tribunal.
出了。
The
那么对于
arbitrators make
前面的
the
这个仲裁
award
庭来讲，这个
for
是
the
太不
prior
这个公平
arbitral
了。当
tribunal.
然，对
It
当
is
事人
not
来讲，可能
fair,
也存在着不公平的。那么
and
这个
it
刚
may
才
not
我举的例
also
子呢，
not be
是我
not
经历过的，
fair for the
是我
parties.
去做首席仲
I
裁员了以
have
后，发现是这样的
encountered
一种
such a
情况，我自
case.
己都觉得也非常的难为情。但是呢，
I
我们
myself
如何在
feel
规
very
则层面上
awkward.
完善，来保护
So we
我们
need to
仲裁员的
improve
合
our
法权益，
rules to
对吧？
protect
所以这个
the
呢是
legitimate interest
我
and rights of arbitrators.
非常感谢这个再一次感谢那
Thanks
个海南国际
again
仲裁院，
to HIAC
感谢给我这个
for the
机会呢，
invitation,
跟
for
各位
giving
老
me
师
this
呢，
opportunity
一起分
to
享
share
和
with
交流。
you.
那么我的这个经验呢，讲的内容呢，一个呢是来自于之前的这个课题的这个研究，
This
以及这个
keynote
5、6
speech
次的
is
这个公
inspired
开
by
的
my
论
prior
坛，那
lecture
么各位专
and
家的这个建议
other
啊。那
forums
么
and
同
other
时呢，也结
experts'
合我们
input
海南
to
国
the
际仲裁
to
院
other
的仲裁规
forums,
则和海
and
南国际仲裁
also
院的这个做法。
inspired
那
by
么我
the
给大家的一个
arbitration
简
rules
单
and
的一个汇报，
practice of
不到之处呢，
HIAC.
请各位老师呢，批
Any
评指正。
comments and
好，
opinions
谢谢。
are welcome. Thank you.
好，谢谢张主任。确
Thanks to
实，
Mr.
张主
Zhang.
任对这个问题啊特别的有发
Mr.
言
Zhang
权，因为我也知道
is
您今年组织
quite
了很多场这
authoritative
个公开
in
的
this
关于这个主题
themes.
的
I
论
know
坛，
you
我
have
也旁
been
听了很多场，
participating in
所
several
以
sessions
这个
on
问
this
题今天您
theme.
算是从
I
方
have
方面
heard
面给我
from
们
your
讲清楚、讲透
presentations
彻了。
for several
相
occasions.
信
You
我
have
们
made a
今天
full
的仲裁员
explanation in
顺
this
着您这
regard.
个
I
讲课的
believe
思
that
路，
our
也回
arbitrators
想起了自
can
己在
learn a
办案
lot.
过程当
And
中
maybe
遇到
your
的各种
lecture
各
have
样的问
reminded
题。比如
them
说
of
有很多
the
仲裁员
problems
会
they
经历，
encountered
被自己
in
完全
past
不认识的
experience.
当事人
For
申请回
example,
避，
some
是吧？或者
arbitrators
是
may
被仲
want
裁
be
机
challenged
构要
by a
求主动
party
回避，遇
he
到
or
一些
she
情
does
况，
not know
可左
or
可右，
asked to
似是而非，
withdraw
形式
on
上
his
看起来没问题，
own.
实质上又有些担心，可能会受到一些这种
in some cases,
然就主动回避吧。在实务当中，这些问题
maybe
都是
the
有的。
arbitrators
所以说呢，仲裁员
decides
的利
to
益冲突问题
withdraw
其
on
实
his
是
or
一
her
个
own
讲
initiative.
起来
The
很简单，
conflict of
但是
interest
处理起
is a
来可
thing
操
that
性又
easily
非常
said,
强，会受到
but
各方各面的
It is
因
very
素去
difficult
影
to
响的一些
handle
问
it
题，比
in
如说
practice.
当事人对自己这
For
一方的一
example,
些情况的不披露，也是会影响
sometimes
仲裁
the
员他披露的
disclosure,
程
the
度、
lack
尺
of
度以及全
disclosure
面
of
性
the
的。
party will also
所以说呢，
impact
在
the
实务当中，这
extent
也
of
是一个特别
disclosure
容易
of
被
the
个
arbitrator.
别想拖
This
延仲
is
裁程序的当事人，恶意利用的问题。您刚才在
tactics that
课程里面
is
讲到的，
applied
首
by
席仲裁
some
员连续
party.
被申请回避的情况，
You've
我
just
们也有遇
mentioned
到
a
过。
case
确实，
where
它导致的最
the
直接的后果就是
parties
没
made
有仲裁员
several
敢接这个案子
challenges,
了。他一
and
听说
in
前
the
面几
end,
个仲裁
no
员都被申请回
arbitrators
避了，
is
那就知道
willing
这个案
to
子肯定是
accept
非常的复
the
杂，当事人非
appointment.
常的
Because
难调
once
和
he
啊，就
knows
是
that
严重
there
的影
have
响仲
been
裁程序的
several
推进。
prior
非
challenges,
常感
he
谢
can
张老
sense the
师刚才
complicatedness of
从
the
这个各
case.
种角度给我们讲的这
Thanks
个
to
仲裁
Mr.
员的
Zhang for
利益冲
your
突的问
sharing
题。
on
那
this
接下来
topic.
呢，我们就进入这
Next,
个互动环节。
we
我
will
们
have a
看
Q&A
在线的
session.
各位仲裁员老师有
Any
什么问题
questions
需要提
from
问的，
our
大家
fellow
可以
arbitrators?
打开麦克风，打开摄像头，向
You
老师
can
们进行
mute
提问。
You can unmute your microphone and open your
我
camera.
今天听到我的
Make
声音
your
吗？
question.
可以听到。
Can you
你
hear
好，那个
me?
张老师，我
Yes,
是那个海
Mr.
南国政的
Zhang.
仲裁员姚远。然
I'm
后
an
呢，
arbitrator with
你好，
HIAC.
我
My
本
name
身
is
也是一
Yao
个律
Yuan.
师，
Good
然后呢，
afternoon.
今年
I'm
呢，我
also
也
a
这个
lawyer
关
this
于这个
year.
话题呢做了
I
800
know
的调
that
研，然
you've
后
done
所以
lots
今
of
天呢，也很
research
感谢
and
您抽出
survey
宝贵的
in
时间
this
给大家
topic.
做一个分享。
Thank you
那是这样，
for
我
giving
在
us
这里呢，
this
跟您那个也向
presentation.
您咨询或者向您请教一个
I have a
问题，我之
question
前
to
碰见过
you.
的一个问题啊，我觉得这个问题
A
呢，应该
question,
特别
a
作为律
problem
师
I
而言的话呢，
encounter
可
in
能
my
是
past
也会经常
experience.
碰见。它怎么的呢？它是我们当时呢在北京的一个仲裁机构呢，就是某家仲裁机
In
构
a
是让我
Beijing
们作为代理
arbitration
人，然后
institution,
这
we
个案
act
件呢是
as
一个3人庭，
attorneys.
然后申请人呢是一家
There
世
is
界
a
500
three
强的一个母公
arbitrators.
司，很
The
大的一个公
claimant
司。
is
然后
one
呢，
of
他
the
呢选
Fortune
择一家
500,
公
a
权所
large
的北
company.
京所的主
They
任作为
choose
辩裁。这
a
个辩裁
director
呢也是一个
of
很有
the
名的
Beijing
资深的
law
仲裁员。
firm as a
然后呢，他
co-arbitrator.
在不
He
披
is
露
a
的时候
well-known
做了一个
lawyer.
无披露事项的一个声明，就是他没有任
He
何利益
makes
冲
a
突，也没有任何
statement
需要披露事
of
项，
no
是做了一个
disclosure
干净的
and
一个
no
声明。
conflicts
然
of
后呢，这个程
interest.
序呢就继续走下去了，那
And
么
then
结
the
果就出来了。
proceeding is
然后呢，双
proceeded.
方当事人
Then
呢
they
对于这个
come up
程序
with
呢没有提
an
出任何的
award.
异议。结
The
果呢，
parties
在
do not
这个结
make
果
any
裁决已经出来
objections,
之后呢，
but
就
after the
当事人
award
被
is
审人
made,
呢通过检索呢
the
发现
respondents
这个红圈
through
所的
search
红
and
圈所的上海
index
分所呢
find
曾
that
经做过
the
和
Shanghai
代理过这
office
个美
of
国
the
外
law
商董事
firm
的一个
once
案件。
acts
然后
on
呢，这个时
behalf
间呢也
of
是在1
these
年之前
Fortune
做过这个案件。
500
当然呢，
a
在
year
指定的时
ago.
候呢，或他选定的时候呢，
But
这个时间已经
when
可
appointing
能
the
这个案子已经结束
arbitrator,
了。但是呢，在
the
之
case
前就
has
是
been
这个
closed.
红圈所的上海分所，而且
But
呢，这个
this
代理律师
Shanghai
呢就是
office
就是这个红
and
圈所
the
上海分所的主
attorney
任，他们2
is
个律师呢
the
都是
director
红
of the
圈所
Shanghai
的
office.
管委会的成员。所以呢，当时
They
呢，
are all
这个被申请
members
人
of
在
the
审
managed
庭，就
committee.
是在
So the
案件这个
respondents
裁决执行的过程中呢，就以这个理由呢提出了撤裁，就
use
说当
this
时
ground
那么这个
to
编裁
challenge
他
the award
应
and
当根据
challenge
的就
the
是有这个披露事项，因为呢，
co-arbitrator.
因为它并不是一个普通的小所，它是红圈所，应该是
Because
公司制的。
the
所以呢，这个世界
respondent
500强
takes
这
the
个公
view
司
that
对于这个
this
公
law
司对于这
firm
个
is
对
not
于
a
这整个
regular
所来
law
说呢，它是一
firm.
个大的客户，
It
应该
is a
他们
very
通过他
big
们所
law
内
firm
的
and
这种案件
that
检索系
500
统，应该很容易能够收到这个
Fortune
双方
500
之间的
is
这
a
么一个
very
代理关系，就曾经的代理关系。
high
那他虽然说
profile
呢可以，
client of
因为这
that
个案件已经结束
law
了，他可
firm.
以做一个就是反正就是我们说的可能说是一个黄色的事项也好，或者说一个需要披露的事项也好，那么他应
So
该
the
提示的话，
respondent
那么我
think
们可以
that
申请人律师
this
阵营可以做一
situation
个
should be
做一个
disclosed
那
by
个
the
挑
arbitrator,
战，
but the
然后
arbitrator
那个
failed
回避的挑战，但
to
是他没有这么做，
make
所以呢，
such
我们认为当时
disclosure.
这个程序
So
上有
the
问题，就提了这
respondents
么一个疑义。
challenged
但
the
是结果
award.
呢，应该还是就是
But the
法
outcome
院
is
吧，法
that
院还
the court, the People's Court, refused this ground. The People's Court refused this ground. So this is a frequently encountered problem for some law firms. When they are expanding their business network, they may in the future encounter such problems. For example, a specific office in a specific geography may act on behalf of the party before. I think this is a serious problem.
你刚才介绍了又是红天所，然后呢又是北
You
京、
mentioned
上
that
海
the
的
law
这
firm is a
个
high-profile
法分
law
所，同时是
firm,
管委会
and
的
they
这个
have
成
a
员。
Shanghai
那么
office.
理论上来
The
讲呢，这个在接案子的时候呢，
pro
应该是要
arbitrator is
做
the
所内
director
的
of
利益
the
梳理。
Shanghai office
那么为什么
who
没有做？
once
那么这个
served
呢，
one
我
of
个
the
人觉得
parties.
呢，就是有一定的问
I
题
think
啊。
he has the
那
obligation to make
个，但是
disclosure.
呢，这个问题是什么呢？这个
What
这
is
个
the
问题呢，
problem?
法院呢，所以我对这个问题实际上有很多这个可以探讨的地方。
I
就是说
think this is a
到法院层面
problem
的时候呢，
worthy
法
of
院往往要
in-depth
维护
discussion for
自己
people's
作
court.
为一个支
People's
持，
court
叫 pro
needs
arbitration
to
这样的一个形象呢，往往可能
maintain
会
his
这个
stance
以这
as
个
a
不构
pro
成这个仲裁呢，
arbitration,
这个不
so
支持。 但是呢，
the
在客
people's
观
court
上
may
在实
refuse
践
the
当中呢，
challenge
确
of the
实也
respondents,
有
but in practice,
也有相应的这个问题啊。那么
this
这
gives
就
rise to
给我们的一个
problems.
启示，就是说，我们作为仲裁员来讲，我们一定要
For
特别
us
注意
as
我们自
arbitrators,
己的一个公信力
we
啊，同时
must
我们
pay
要注意
attention
我
to
们
our own
这个代表了仲裁
credibility.
机构的这个公信力。
And we must know
同时
that
呢，就是
we
说，对于我们
represent
当
the
事人来讲
credibility
呢，
of
我
the
们一定要特
institution.
别注意，我
And
们
for
要
the
及时的
parties,
去搜寻、
parties
搜
shall
索这
search
个仲裁
the
这个
information
这个仲裁
of
员
the
他的信息，
arbitrators.
因为这个信息，如果法院说我不支
If
持
the
你，
people's
他
court
可能他
refused
也有理由，
such
他说这个信息
grounds,
你可以查到的，
because
或
courts
者
may
说这个
take
信
the
息你
view
当
that